Grace and peace, everybody. Good morning. Good morning. All right. Hopefully, you all are well rested. We got hopefully, a fun show planned today. We're going to jump into the YSL case, check out what they're doing over there. We're going to go over the writ of mandamus that was filed by Weinstein for Kendrick. I forgot Kendrick's attorney's name, but y'all know who I'm talking about. We're going to look at that, and then also we're going to look at the top funny things that have happened in the YSL case as of yet. So if you're new to the channel, come on in, jump on in. Please go ahead, hit that like button. You're now part of the best live chat on the planet. Feel free to jump in, say hey to all the good people as they file in as well. I do want to let y'all know, I don't know if you're familiar with this young lady. Her channel is named Infamous Sylvia. Just met her yesterday by way of the lead attorney, and she actually has been going to the courtroom every day since this YSL case has started. I don't know her background. I don't know her history. I'm going to try to have her come on the show to talk about who she is, but my goodness, in the morning, like she literally has been going for almost, 95, 96 days. So super interesting young lady. She has a real fun community. I'm going to drop her link in here. Go check her out. Tell her that Dear Woke Christian sent you. And because she actually live streams all the way to the court all day. I think she comments, if you will, on what's going on from her phone. And then she live streams home every day. Pretty wild. So hopefully we'll have her come on the show. I reached out to her and asked her to come on because I would love to hear a little bit about who she is, why she's infamous, of course, and what's got her going. So what got her involved in this, because it's super interesting. So be prepared. It'll probably be today, maybe even tomorrow. We'll be doing that. So I'm looking forward to that as well. Good to see you, Q. Thank you so much. Mr. Weinstein is Kendrick's attorney. I just couldn't remember Kendrick's last name. But thank you so very much for stopping by this morning. I appreciate you at the current moment, at this juncture in time. Y'all know Judge Glanville ain't got nothing going yet. Bless his heart. Let me pull it up, make sure it's ready to go. So like the current second, nothing's popping over there. So let's do this. Look at this writ of mandamus. And it is right here because it's not right here. There it is. Ha-ha. Okay, so what did they do now? DeMonte Kendrick, his attorney, is basically asking the Supreme Court of Georgia to step in. I know a lot of people were wondering, well, when is the Supreme Court going to step in? When is the Supreme Court going to do something about this? Well, now we know. They've actually filed a writ of mandamus to say that they want the Supreme Court to do something about what's going on in this case, because I'm sure you've heard them say it. Oh, well, you can take it up on appeal. You can take it up on appeal. Well, that sounds great and all, but please keep in mind, this case has all the potential of lasting multiple years. I've heard as short as a year and a half, as much as 3 years. So I have no idea. So imagine if Judge Glanville did in fact do something wrong on June 10th, 2024. But you have to wait till June 10th, 2026, when the case is over, to file an appeal. You've wasted 2 years and a lot of cash in order to get to that place. That's crazy. And then only to have it find out when you appeal it and they say, yeah, back in June 10th, 2024, he really did screw the pooch. He really messed up. This is horrible. And they throw the whole thing out. 2 years, 24 months has been wasted of your life. I don't know how many countless hundreds of thousands of dollars have been wasted of your funds. That's crazy. So that's why they're filing this, and it's an emergency writ of mandamus. So let's keep going. DeMonte Kendrick's emergency petition for writ of mandamus and stay of proceedings. And they list a whole bunch of people here. This thing got a table of contents, y'all. This thing is serious. Oh my gosh. Hey, is that my guy? He's out of witness protection. It's the Independent Mail. Thank you so much for the very kind super chat. Let me go ahead and give you a little shout out for that, by the way. Rico. Thank you so much, man, for the Rico Defense Fund. Thank you so much, Quentin. I appreciate you, brother. Thank you. And look at this. Hey, let the floodgates open up. Thank you so much, Donna, as well, for the very kind super chat. I appreciate y'all. Y'all, thank you so much again. And if you're new to this channel, I've seen lots of people say, I'm new to this channel. That's super dope to have you. All I ask that you do is that you hit the like button and say hey to the people when you jump into the super chat. I'm going to jump into the live chat because you're a member of the best live chat on the internet. So we appreciate having you. Thank you so much. And let's see what we got here. All right, I'm gonna scan through this table of contents because there's some interesting parts and there's some high level parts that are not really that exciting. So they give all of their cases. I don't think I've ever seen this before. Maybe this is something that's germane only to writ of mandamus, where they give all of the cases on the top end. And maybe that's something new. So let's jump here to page 6 of 83. Oh, by the way, it's not really 83 pages. It's really 24 pages. So the other pages are a bunch of other filings and motions that have been filed and motioned before, and they're just tacked on to the end of it. So it says 83 pages. It's really not. It's only 24. Because yesterday we was traumatized. Like, whoa, this was traumatized. It comes now. DeMonte Kendrick. He's a petitioner. I don't know what's DeMonte's street name. I know he can't be Rich Homie Quan because that's our friend from yesterday. What is his actual name? I know Kiana's going to tell me. So just let me know when you find his real name. By and through his undersigned counsel, and brings this emergency petition for writs of mandamus and a stay of proceedings showing as follows. All Judge Glanville would have to have done is just been willing to listen to their petition. But let's see what happens. Jurisdiction and explanation of emergency nature of petition. This emergency petition concerns allegations of serious breaches of Georgia Code of Judicial Conduct and violates petitioners' state and federal constitutional rights. Wow. I mean, they're going for the jugular. He said the court, they said the state, and the federal constitution. Man, they are not playing games. This petition relates to conduct of Chief Justice Glanville, also known as Glanville, and not to any rulings or orders of the judge. So they're just saying, hey, it's not the rulings and the orders, it's his actual behavior. I knew it. Yak Gotti. That's who DeMonte Kendrick is. All right, I'm going to call him Yak Gotti. That's such a weird name. This court has jurisdiction over the matter of Georgia, and it gives the code. In the case at bar, original relief in the form of motions for recusal have been filed and denied 3 times by 3 respective motives. Likewise, Glanville has denied the Movant's respective requests for a certificate of immediate review 3 times. So immediate review just really deals with the fact that we don't need to keep this case going forward, because when we get to where we're done and we have to come all the way back, run it back in order to get relief or get the solution, that's not going to work. And I agree with that, because this is horrible, but all right, let's keep going. Has obstructed, let me see, 3 times. Glanville, as chief judge, has obstructed defense counsel's attempts to have a disinterested party review the numerous allegations contained in at least 4 affidavits which allege judicial misconduct and unfair proceedings. These affidavits, if true, would constitute serious violations of the Code of Judicial Ethics. Why do you think Glanville is not willing to hear this? It seems pretty. Now, granted, I don't think it's just a positioning. I don't think it's just a tactic. I heard that lawyers will say, you sneeze, mistrial. I got you there. But why do you think he's not listening to some of the things that? Because it seems pretty cut and dry to me. It seems pretty cut and dry to most people. You're having special meetings with one side of the argument and not the other side with a very key witness. You're threatening a witness to put him in jail indefinitely. I just don't see how this is going to go. I just don't see it. I have no idea why this is this. I'm like, am I missing something here? Am I doing something wrong? Am I looking at this again? I'm a pre-K law student. I know nothing. Okay. But it just seems extremely easy to pick out the problems, the errors, and the missteps in this. Citing a lack of evidentiary foundation caused by Glanville's own recalcitrance, uh, recalcitrance in refusing to provide a transcript of a secret ex parte proceedings. That right there alone. Why are they not giving the audio clip? And I don't know. I don't know what all it takes to get a quote unquote transcript of a secret meeting. But remember, he told Steele that he would do some redactions and then give him the redacted form. Why? Just give him the thing. That's craziness. And so Glanville has hindered defense counsel's ability to effectively pursue relief by claiming judicial privilege while denying certificates of immediate review. Assuming this court would not get the opportunity to review the decision on the multiple motions to recuse unless or until the underlying case was concluded. Again, taking it all the way to the end. So whenever it is, 2050. Can you imagine that? Like the amount of time that would be wasted if in fact Glanville is found to have messed up and they got to run it all the way back 2 years, run it back a year and a half, the countless man hours, the waste of time, and of course the waste of resources. I still believe that this is meant to be I don't know how, but this case is a gigantic money transfer. I don't know how it works, but this is just a gigantic waste of financial resources as well as experience and such of that nature. Okay, let's keep it going. Glanville continues to hide behind a purported standard that his actions would be reviewed in hindsight for the abuse of discretion. And I think, and we've heard him say this as well, like, hey, well, take it up on appeal. Yeah, whatever you say, but take it up on appeal. That's crazy. He's saying that, hey, sure, whatever I'm going to do, if I'm wrong, then it'll pop up on appeal, rather than just consider that maybe what he's doing right now is not right. I still think he's been doing this before. I don't know. I don't have a way of proving it, but I wonder if he's done this before, and that's why he's so headstrong about it, is because he's been doing it, and he wouldn't want it to become clear and evident that he's done this before. I don't know. It seems crazy. Glanville's obstruction, I'm just real quick checking. It does not look like they've started. They don't even have head movement yet. They don't even have the camera up yet. Okay, camera's up. I take that back. Camera's up now, and they're saying it's starting in 15 minutes. So they pushed it back to 9 o'clock. So I don't even know when the camera is going to pop up, but we'll be ready. Here, let me make sure it's cued in. All right, we are going to definitely work on this. All right. Okay. So every time I leave from here, the page goes back to 0. That's craziness. All right. Glanville's obstruction of defendant's defendant's right to a fair and impartial trial has risen to a level that defense counsel now believes all attempts to obtain relief in the Superior Court of Fulton County will be ineffective. 3 motions for recusal have been filed and denied. 2 writs of mandamus have already attached to the instant case, which were filed and pending for more than about 1 year. Therefore, any efforts to file a writ of mandamus in Fulton County that would be heard by Chief Judge Glanville would result in frustration and lack of attention. Wow. They're not playing games. They are not playing games with Judge G. They're not playing games with Judge Glanville at all. Here, let me make sure this is ready. Okay. Yeah, I don't see it yet. Okay, cool. All right, let's keep this rolling. Listen to this last sentence right here. Glanville's court is where writs go to die. Wow. That's so scathing. So you're not going to give justice. You're not going to do what you need to do. We're going to just file something and you're just going to let it go there to die. You're not going to do the right thing. They're making a very harsh statement here that Glanville's not going to do the right thing. Glanville's not about pursuing justice and giving relief to those who have been wronged or those who are being wrongly accused, but rather he's just going to do whatever he wants to do, and writs go there to die. That is not a positive statement by any means or measures. As the present petition for writ of mandamus would go to Glanville, if filed in the Fulton County Superior Court, petitioner has no option other than for the Georgia Supreme Court to exercise its discretion and consider defendant's claims. So they're saying basically, if we file this with Glanville, he's just going to sit there. It's going to sit on his desk. It's going to sit in his inbox, or he's going to leave it on red. Is that how they do it on an iPhone? Is it on red? Is that what it's called? He's not going to do anything. So we're saying, look, we got to go ahead and get something taken care of, because otherwise this case is going to keep on going and nothing's going to be made right, which I think is pretty sad. All right, let's keep dancing. A secret ex parte proceeding was held on June 10th, 2024. In attendance were Glanville, sworn witness Kenneth Copeland, prosecutors Love and Hilton, investigators from the Fulton County DA's office, and members of the Fulton County Sheriff's Office. As a result of the proceedings, on June 12th, petitioners requested that the presiding judge, Glanville, recuse himself from the petitioner's trial for, among other counts, count 2 of the murder, whatever, special lettering right there. So he's saying, hey, I have no idea how he's going to justify that special meeting, that ex parte meeting. I have no idea. But, I mean, we'll see, but I just don't see how he's going to do it. Despite the proceedings, all requirements of uniform Superior Court rule, filling all that in, for recusal was summarily denied without following the required procedures. So there's actually a procedure for recusal. And I think we saw that. He was shooting them down like duck hunt the other day when Brian Steele was asking him to recuse himself, when motions were being filed. He was just shooting them down. So I got you. But they're saying there's actually a procedure that he must do, and he wasn't even doing that. Glanville denied a request for a certificate of immediate review. And let me real quick. So from my understanding, a certificate of immediate review, when you look at the Fonnie Willis case and such like that, when Judge Scott McAfee gave his order, he immediately gave permission to the Trump team to have it immediately reviewed. The judge that gives the order must give the certificate in order for you to get it reviewed in appeals or whatever like that, which seems totally weird to me, because then you got a situation here like Glanville, who is doing wrong. And of course, he's not going to say, hey, I'm doing wrong. By the way, you can go ahead and have it reviewed immediately. So we'll put a hold on this case so you can get it reviewed by my boss or somebody above me. There's no way that would happen. Did the screen just jump? It sure did. Okay, there we go. I might be hunting. Okay, maybe I'm making that up. It looked like it jumped. Okay, so that being the case, so they need to get Glanville's permission to have it put in immediate review, because again, looking at what happened with Scott McAfee, he gave them permission for immediate review. It went to the appellate court and they said, hey, y'all might need to pump the brakes on doing anything right now. So they actually put a stay on the entire trial, or hearings at least. So I think that's what he's kind of worried about, I think. But let's keep going. A formal order denying the motion was entered on June 14th. So that was a week ago, 2 days after the motion for recusal was filed. So I think they're doing a great job with their filings, because there's a certain window of time that you have in order to file. And I think they're doing a good job with that. And so they mention that quite often, like, hey, we followed all the rules. We're following all of the proper steps in order to seek relief in this regard. But let's keep going. As chief judge of Fulton County Superior Court, Glanville holds a unique position within the county, which carries a significant amount of weight and power among his fellow county judges. Glanville has repeatedly refused to issue a certificate of immediate review that would permit the Georgia Court of Appeals to review his decision on the recusal motion. And that, to me, I think that's probably the worst thing that he's done. One of the worst things he's done is basically not even consider that what he's done is not right. But let us continue. Therefore, invoking the original jurisdiction of this court to issue writs for petitioners only recourse. If not considered by this honorable court, the still incarcerated defendant would be forced to wait for at least another year or more of trial before seeking appellate review. So that's kind of what I said before. If they don't get it done now, then they will not be able to get it done until much later. So the further you drive down is the further you have to drive back. And I think that's what they're trying to really lay out. Like, we don't want to have to drive back because we know we're going to have to run it back. So why don't we go ahead and deal with it right now rather than wait till the end of the trial, because you're going to still bring it back. And those people will never get that money back either, or the time. The appellate procedure in this case at bar will be extremely lengthy and cumbersome, with more than a year's worth of transcripts to review. Apparently, these transcripts are beasts. So it's not just what was said. I don't know what the transcripts entail, but apparently they are very, very weighty, very, very lengthy. So the process of it, so there would be less transcripts now than it would be in a year and a half, 2 years, a year, whatever. Because of that, they're like, let's go and get it now, because we're going to need to get those transcripts, because you need transcripts in order to do an appeal, which is kind of wild, but it is what it is. All right, let's keep this game rolling. Emergency relief is requested because the witness that was coerced by Glanville is presently on the witness stand. Absent emergency relief from the court in some form, Glanville will control the scope and substance of undersigned counsel's cross-examination of Copeland. So Brian Steele has already told him, look, when I get my hands on Woody, I'm going to ask Woody, what did they do to you in that secret meeting? Tell me, Woody. Tell me. Tell Mr. YS Steele, what did they do to you, Woody? Did they coerce you? Did they threaten you? Did they challenge that they were going to keep you in jail for an indefinite amount of time? What did they do to you, Woody? Come talk to me. Talk to me, Woody. Judge Glanville don't want that. Judge Glanville don't want that smoke. So that's what he's saying. He said, and Judge Glanville is the one that says, you can't ask that question. So if Brian Steele comes up and says, hey, Woody, tell me about that secret meeting, Glanville could say, strike that. You cannot ask that question. Crazy, right? Glanville's the one that did wrong, and he is the one that he's the one that supersedes, looks over the questions that are asked by the defense and the prosecution. This is dirty business. All right. Of the counsel's cross-examination of Copeland. Anticipated areas of cross-examination include Brady material that the counsel believes was disclosed in the proceedings but not provided to the counsel as required by the law, as well as the coercive joint efforts of the bench and the state. Tell me, Brady. Tell me, Woody. Come here, Woody. Come here. Tell Mr. Steele. Tell YS Steele. What did they do to you? Tell me what they did. Show me how they coerced you. Show me how they twisted your arm behind your back. Tell me how you felt when they said they were going to keep you in jail indefinitely. Talk to me. I'm here for you. I'm listening to you. I need to get some quiet music. I'm here for you, Woody. Talk to me. Judge Glanville could tell him not to ask those questions. This is crazy, man. Talk to me, Woody. I'm here to listen. I'm listening to you, man. I want to know what you thought. How are you feeling, Woody, when they brought you in that room and there was 13 other people in there, Woody? How did you feel? Did you feel threatened, Woody? Little Woody, did you feel threatened? Did you feel like there was like you was in a gang? Did you feel like they was about to jump you, Woody? Tell me what you thought, man. Talk to your boy. Talk to me. I'm here for you. I'm here to listen. I'm here to take care of you, man. This is craziness. Okay, let's keep going. Given the conduct during the ex parte proceedings, at least an appearance of impropriety, if not an actual impropriety, casts a pall over any ruling that Glanville may make during counsel's cross-examination of Copeland. So unless Glanville sits there quiet and plays on his phone or pets his dog, any kind of objection is going to seem wrong. And I feel like that's a good point. Like Steele is not going to be able to ask questions without Glanville saying something. And what's going to be the purpose of it? I promise you, it's going to be, I'm asking you to recuse yourself multiple times. That's what's going to happen. They're going to be saying that a lot that day. Okay, let's keep this going. As Glanville has found petitioner's motion for recusal to have been filed and presented in a timely fashion, the Weinstein affidavit to be legally sufficient, and the affidavit containing facts that, if proven, would warrant recusal, petitioner requests that the court grant a writ directing Glanville to adhere to Rule 25.3 and thus assign the motion of recusal for a hearing before an unbiased judge. Wow. They ain't playing games with him. Come talk to me, Woody. Come talk to me. I'm listening to you, man. Come on, man. I'm over here listening to you. What you need, man? What you need? You want me? Come on, Woody. Let's talk. Petitioner further asks that the court ask of this court that proceedings in trial in whatever that is be stayed pending resolution of the motion of recusal. To me, it makes perfect sense. Petitioner further asks that the court ask this court for a writ ordering Glanville to produce immediately and certainly no later than prior to the start of the cross-examination of Copeland an unredacted transcript of defendants of the secret ex parte proceeding held on June 12, 2024. Petitioner also asked of the court that it enter any further writs of or orders it deems appropriate given the actions of Glanville. Wow. I mean, I don't know what else to say. I think that is a very solid case, in my opinion. I don't know anything. My name is Jason. I'm a pre-K law student. But it sounds like they know what they're doing. They've definitely done their homework, and that's, wow. We're going to keep reading through it. But I appreciate everybody stopping through today. I got my favorites up in the building. My favorites. Independent Mail is in the house. Thank you so much, Susie. Always good to see you. Thanks so much, Clive. Clive DeVillers. I see what you did there. Good to see you, sir. I think I saw Meek in the buildings. Some new faces as well. Connie. Good to see you. Take it up on appeal. But what year would it be? This is a sham show. I don't know. It would be after all this is done. So if the case ended today, it's fair to say that there would be a bunch of things that need to get finished in order for them to file for appeal. So let's say that they finished today on the 21st. They would have to probably wait to maybe 4th of July week, maybe the week after. Everything is done. Everything filing is done. All that kind of stuff. Boxes are filled. You couldn't file for appeal tomorrow or this afternoon. So he's going to be in jail for 2 weeks at least. Then you can file for appeal. And by the way, that doesn't mean you get out of jail. So you're basically going to go to jail until the appeal starts. And if you don't get a motion to get them out of jail or get a bond or whatever like that, they're going to be in jail. This is craziness, man. Extremely disappointing. Yeah, Robin points out that The original statement was that they would keep Woody in jail until everybody was tried. And again, that could have been in excess of 4 or 5 years easily. Amazing. Good to see you. Good to see you, Polly. Thank you so much for stopping by. Did I see you? Did I holler at Brian Frost? Can the jury sue the judge and the lawyers over lost pay and time if it ends in a mistrial over their misconduct? Because it would be. I got a bad feeling no, because otherwise we would have heard about it. Can you imagine like a class action suit? Um, Jurors class action suit. It seemed like they should be able to, but I got this feeling it's your civil duty, your civic duty. I'm sorry, to be in a jury, and I got a feeling it's no. But that's a great question though. I see you. Good to see you, Carol. Always good to see you. Thank you for stopping by. I see Sarah in the building. Thank you very much for stopping by. Good morning, everybody. Always coming in, giving that shout out. Shout out to Donna. Thank you so much. And I appreciate y'all stopping by. I think I got everybody. If I missed you, please don't hold it against me. Please don't hold it against your boy. I did see. I really thought there we go. There she is. Char's in the building. Good to see you, friend. Good to see you. Roxanne Shante. I like it. Oh, hey, what's up? Thank you so much, ADH person. I appreciate it. What does ADH person says? Judge Chaos ain't got both paddles in the water. Ain't no doubt about it, fan. Faunie Adams, DA, not far behind. I agree. I agree 100%. I just hate it because he seemed like he was a decent person. I've heard lots of good things about him as a lawyer, lots of good things about him as a judge. It just seems like something's wrong here. I don't know what it is. And it could be some shenanigans. It could be just that he just needs to tap out. Maybe I heard somebody allude that he's downstream, he's very close to retirement. And maybe he's just trying to this be his last good case before he retires. I don't know. And I use the word good very loosely. Okay, so nothing is happening over here. Wait, let's double check. All right, let's check. Oh, we got a camera. Okay. What page am I on? I am on page 11. I remember that. Okay. We got camera. So sorry, right here. We got camera. Let's get it. All right. Where am I? Why am I not in the box? There I am. I like the way that looks. Some reason or other, my camera, I don't know if I got bumped last night or what. Yeah, we got to fix that I'll be right back. All right. There we go. There we go. All right, so now we're cooking. Okay, so we know what they're doing over there. So let's just go ahead and jump back over here. All right. Back to page 11, see? So we're ready to jump back in when they're done. All right, so I don't know why this seems to be, there's got to be more to it, because at this current moment, this seems extremely cut and dry to me. Not because I want Judge Glanville to be wrong or I'm rooting for Young Thug or whatever like that. It just seems like it's legal malfeasance, in my opinion. But let's keep going. Okay, so issues presented. Is this page 11, Jason? It is page 11. Whether Glanville was correct in failing to follow the mandate of the U.S. USCR 25.3, by refusing to refer to a motion of recusal to an unbiased judge for hearing following the argument on June 12th, particularly after making findings in the order on June 14th that the motion was timely and attached affidavit was legally sufficient. Yeah, he did say that. So he's like, I read what you said, what you posted on Friday, and it was all done well. It was all done correctly, but I don't care. That's basically what he said. All right. And that the affidavit contains assertions of fact to support the allegations of bias and impartiality. Statement of facts. Procedural history. In January 2023, wow, nearly 18 months ago, trial began in Fulton County Superior Court in State versus DeMonte Kendrick. It was a little yak. No, Yak Gotti. Jury selection took more than 10 months, with trial before the selected jury beginning November 23. Okay, I remember that. Yeah, this thing has been going on for a minute. Following the secret ex parte proceedings on June 10th, 2024, petitioner filed and presented a motion to recuse an accompanying affidavit from Douglas Weinstein, Exhibit A, to Glanville on June 12, 2024. The motion to recuse was based on the impermissible secrecy of the ex parte proceeding and the violation of the Judicial Code of Conduct that occurred during this secret proceeding. I mean, what else? What else can you do, my guy? Literally, what else can you do? Thank you to everybody that's stopping by. We are waiting for court to start. The cameras are on, and we got the usual Georgia seal right here. So we're just waiting for the head movement, waiting for that camera to move, and then we can get popping and locking. But we are ready to go. So in the meantime, in between time, we're reading the the writ mandamus to the Georgia Supreme Court in order to get some relief and get somebody to step in and stop this case and review whether or not Glanville was out of pocket for having an ex parte meeting. The motion was summarily denied in stantar with a formal order issued on June 14th, 2024, Exhibit B. That's what I'm saying. This is not really as long as we think it is, because a lot of those are, at the end is just all these exhibits that they give. The secret ex parte proceedings, a central figure, perhaps the central figure in the state's case against Kendrick, Yak Gotti, and the other defendants is Mr. Kenneth Copeland, Little Woody. On Friday, June 7th, wow, that was 2 weeks ago, Copeland was sworn in after being given a grant of immunity and being warned by Glanville that incarceration may be the result of refusing to testify. Copeland continued to plead the fifth. And we see the examples there. Copeland was held in contempt and ordered incarcerated by Glanville on that date. So that was Friday, 2 Fridays ago. Yes, we all saw that. Glanville instructed Copeland and all parties that Copeland would be returned to court on Monday, June 10th, right, at 8:30, where Copeland would announce whether he was prepared to testify. Unknown to any member of the defense counsel, an ex parte proceeding was held in Glanville's chambers on June 10th, 2024. That's why his case started so late that day. Among attendees was Glanville, ADA Love, ADA Hilton, investigators of the Fulton County District Attorney's Office, deputy sworn witness Copeland, and Copeland's attorney, Miss Kayla Bumpus. All right, no member of the defense counsel was present at the ex parte proceeding, despite Copeland's invocation of his Fifth Amendment rights being at a critical phase of the trial. Neither Glanville nor any member of the court staff nor the Fulton County DA's office made any member of the defense counsel aware of the ex parte proceedings, either before, during, or after the proceedings. Amazing. I don't know how he's going to pull this off. One or more members of the defense counsel were later made aware of the ex parte proceedings with sworn witness Copeland, though not from Glanville nor from the DA's office. Okay, so we know it wasn't DA Love or Hilton. We know it wasn't Glanville. Gotcha. Specifically, Weinstein learned that Brady material was disclosed in the ex parte proceedings and withheld from all defense counsel. Upon information and belief, the following events occurred at the ex parte proceeding. With sworn witness Copeland in the chambers of Glanville. All right, that is wild, y'all. Thank you so much. It looks like about 130 of y'all are stopping on by this morning. Thank you so very much for stopping by. I appreciate you. And you now are a member of the best live chat on the planet, and your membership dues are that you hit the like button. Go ahead and hit the like button, say hello to everybody, and make sure you let them know who you are and where you're from. Let's keep it going. Let's go. Upon information and belief, Copeland announced that he would invoke his Fifth Amendment right and not testify. So he said that again. Upon information and belief, Copeland stated that he would rather sit in jail for 2 years than testify. Upon information and belief, Glanville informed Copeland that Glanville could keep Copeland, our sworn witness Copeland, incarcerated until additional defendants were tried, not just the 6 defendants currently on trial. Oh, so even more than the 6. Wow. Yeah. Man, that's crazy. That's so crazy. Upon information, I believe ADA Love and Hilton informed Copeland that there were over a dozen defendants left to try. Information, I believe, following above coercive actions by Glanville working in concert with one or more of the attorneys from the Fulton County DA's office, sworn witness Copeland stated that the ex parte proceeding that he would testify. Really? Glanville also presented sworn witness Copeland with a printout of the perjury statute and a false statement statute of the state of Georgia during his ex parte proceedings. Wow. Sworn witness Copeland stated to ADA Hilton that if called to testify, he would simply lie on the stand. Important Brady material that was yet to be provided to Yak Gotti. Wow. In response to Copeland's statement that he would lie, ADA Hilton stated that she would not prosecute sworn witness Copeland if he were to lie on the stand. Important Brady material that is yet to be provided by Yak Gotti. That is crazy. They literally say, "Hey, we're not gonna prosecute you if you lie." Wow. Hey, what happened? All right, let's see. Sworn witness Copeland also stated to ADA Hilton that he would testify that he killed Donovan Thomas, Little Big Nut. Important Brady material that has yet to be provided to Kendrick. Yak Gotti. Wow. In response to sworn witness, Copeland stated to ADA Hilton that he would testify that he killed Big Nut. ADA Hilton told Copeland that she would prosecute him for perjury if he testified that he had killed Thomas. Important Brady material that is not provided to Yak Gotti. Wow. I'm hitting play. Is it going? Hold on one second. Is this? I'm sitting here. It's not starting yet. All right, let's pull this in. Let's see what we got. All right, let's see. Okay, I'm right here, as y'all see.
It's gonna tough him. What the?
Oh, yeah. Forgot to tell you. I found a
given he wants these things redacted and those items are in dispute. And those would be the 10 timestamps that you received this morning via
email. Drop a 1 in the chat if you can all hear.
Are there any sections that, since it's your video, basically, or you're seeking to admit the video. Do you have any sections that you all have decided you're going to not play or not in contention? Have you vetted any of those with the defendants?
We have not, the defendants, and I don't know if Mr. Shaw was getting ready to do that, based on what we submitted to them, we do not know if there's any parts that they agree with or not. We know that everything that Mr. Shaw has sent us, in dispute with us.
All right. Okay.
And so,
All right. So I'll just take by the numbers, and then we'll move on to any other persons that wish to be heard about. So what are you marking that February 21st interview as?
this is going to be 379, excuse me, 378, Yankee Delta.
Okay.
Oh my gosh, for the YouTube Premium Fund. Thank you, Susie.
At least until we get the hard copy before you copy.
All right. Has that already been sent to all defense counsel as well?
Yes, Your Honor.
Okay. All right.
So,
Yes, sir.
are you gonna?
That's hilarious, Robin.
You have it queued up.
Yes.
Okay, awesome.
No, sure, you're fine. You're fine.
Was your intention to go through mine first, or?
Yeah, but I want them to at least queue it up. So why? Okay, we'll take the first one. I believe that's at 3:59:50 to 4:00:20, and it apparently.
The first three, Your Honor, are all statements made by investigators. I believe they're all by investigator Gaither.
All right, let me just kind of flesh out as well, just for purpose of record in our discussion. Number 2 is 4:08:40 to 4:09:40, and number 3 is 4:10:55 to 4:11:05.
Right.
And the first one, you've indicated that Gaither gives a speech about the need for people to step up and cooperate. Number 2, Gaither gives a speech about the work they have done. And number 3, Gaither gives a speech about doing this to protect Casey's baby girl.
Right. And obviously speech is my commentary, but it's essentially the narratives given by detectives throughout the interview, which are basically giving argument and kind of parroting the state's argument throughout this case, which I think is improper and unnecessary and fails 403 because there's no probative value to investigator Gaither pontificating about the need to protect the community and the need for witnesses to come forward and her quest to protect Mr. Copeland's child and things of that nature. So, I mean, they speak for themselves. So, Your Honor will hear, and then I guess we can argue about it.
Okay, all right.
And Your Honor, the emails are sent to you now. For reference on the transcript, this would be page 13, line 19 through page 14, line 3. And we'll start a little before for context. We'll start at 3:59:35.
He does look relaxed. You're right.
haven't did none of these niggas, man. Listen, what you not understanding me frustrated, man. I did nothing. What you not understanding is if you have it in your mind, we can't do nothing about that if you're not speaking on it. We don't know what's in your mind and what you know. And that's what's making it even more fucked up because you holding on, and everybody else just running rampant. I'm going to jail for, I'm taking the blame for everything. I'm in jail for probation, parole, whatever you want. That's what you're in jail for. If there was some other charges on you, Woody, they would be there. And you would see it. They got me in jail for probation until they find out if I shot one boy.
And we ended at 4:25. We ended that play at 4:25.
Okay. All right. Why does the state believe that that's admissible?
Yes, Your Honor. Mr. Copeland testified that Detective Gaither, during the course of any of these interviews, were forcing him to name a suspect. What she's doing here, for context, this interview is the day after Mr. Copeland, his child, and his child's mother has been shot at. And if you can recall, in the February 20th interview when he was with Detective Curry, which has been played before the jury, Detective Curry attempted to get Mr. Copeland to tell him who did it. He did not. If you can recall, he would not say who did it. Detective Curry went into a conversation with him saying, I know you know, I could tell by your body language that you know. Then when he was by himself with Deshawn, his girlfriend, he told his girlfriend, I know who killed me. I know, I'm not killed me. I know who shot at me. This is the next day in which they knew that he had a relationship with Gaither. If you can recall, in that February 20th interview, they kept telling him, you need to talk to Gaither. You need to call Gaither. And now Gaither is trying to get him to come forward with whomever he saw in the day that he was shot at. And so what Gaither is doing during this portion is telling him, I can't stop them from shooting at you. I can't stop them from doing anything if you don't tell me what happened. And majority of this interview is her trying to encourage him to tell what he knows. And that is, again, in contradiction to what Mr. Copeland has said on the stand, that one, that they were forcing him. They were not. And you can see throughout the conversations here, they're never forcing him to do anything. Two, Mr. Copeland eventually says that I wasn't, that Tay never killed me. I think he said, I swear on my child's grave or my mom's grave that Tay never did it. And this whole entire interview is them talking to him about what has been happening, the shootings, the retaliatory shootings, and encouraging him to tell them who he knew shot at him, his child, and his child's mother. So I think this is relevant, one, to contradict Mr. Copeland's in-court testimony that they were forcing him to do anything. Two, to show how the police were attempting to get him to give information, which was in a calm fashion, which was in a fashion to get him comfortable enough to be ready and prepared to make an identification. And so we believe it's relevant to show the jury they weren't forcing him to do anything.
Mr. Short?
Well, I think if you look at that exchange in isolation, it is a narrative by the detective. It's not prior inconsistent statements by Mr. Copeland, but you might say it's not that egregious or, what's the big deal? I think as we go on and we discuss the next two excerpts, it kind of builds upon itself in forming this narrative of people are not coming forward. Our job is so difficult. We got to do this to protect the community. We got to do this to protect children. And that's my concern, is pushing that narrative through Gaither's words during these interviews are admitted for the express purpose of Mr. Copeland's prior inconsistent statements.
Let me make a suggestion. Why don't I just listen to the three
Yep.
together, and then we can have another discussion. Okay.
Great.
All right. Let's play 40840 to 409, or actually 40840 through 41105.
No, sorry, 40836.
And even if I did see something on Twitter, I can use what Twitter says. You the victim here. That's what you're so used to being in fucked up situations, you don't realize you a true damn victim.
When the police came to my house, I wasn't no bitch. I was a suspect.
I can't vouch for what nobody else did. This is my case. This is my case. If you was a suspect, Woody, you would have got locked up that night. That night. You admitted to shooting back, you would have got locked up that night. Am I correct? Okay, so I'm asking you, who the fuck shot at you? Either you gonna tell me or you not, or you just gonna stay in this.
Dad bods deserve
Amazing.
better teas.
I found this brand called True.
If you go to the streets trying to kill you.
I ain't even going to the street.
If you wanted, you would have been told the first time.
Wow, he changed the
The first
flow.
time you would have told me. It ain't just about you and your life, because your baby was out
You know,
there.
this first time, I think I was joking with
What you tell me the first time?
What I tell you? You don't forgot what I told you the first time?
The first time that I talked to you a few weeks ago about the incident on the highway. You didn't tell me when it was time to tell me. You didn't tell me. Us talking off the record, it's like it never happened. It's like it never happened, and I can't work like that.
You expect me to help you, but look at what happened to me.
I'm expecting you to help you.
I'm getting shot at and locked up.
It's like I'm talking to a brick wall, Woody.
First, I try my best not to cry.
And it's all right to cry.
I cried the same night they came. I did. I let it out. But I scratch every day. You know what? I just shot my car. You know what I was doing? I was still out. I ran 4-wheelers everywhere.
I know.
I wasn't riding all right. You know what I'm saying? Because I know everybody wasn't out to get me.
I'm not saying everybody out to get you, but the folks that are out to get you, obviously they coming for you. And me as a police officer, if you don't give two shits about your life, I care about your baby life.
I care about her life.
She can't get
my life and my girl life.
Exactly. So help me do this shit.
Help me
They out
help
there
you.
now. They out there by themselves.
But you not telling me nothing.
Cause I'm in jail.
You right here right now. They out there by themselves, and the folks that shot at y'all.
And ended a little bit later at 41117.
All right.
Hey, Your Honor, I have a physical copy of it.
Thank you.
It will be 378 Yankee Bravo 2.
Thank you.
What we doing? What we doing? Chicken Bruce, I am not here for fashion advice. They love talking about this.
All right, sir. Sure.
So, Your Honor, my objection to
I agree, sir.
what the playing of what Investigator Gaither says is that Investigator Gaither, again, not the intended declarant of these statements, these out-of-court statements, is essentially making an argument that the jury will hear that it's a future dangerousness argument. It's an argument that, you're either on the side of the quote-unquote gangsters, or you're on the side of the people that are trying to protect children. It presents a false dichotomy, and also it invites the jurors to consider subjects and consider things that are not supposed to be in their purview as the finder of fact. Well, future dangerousness, protecting the community.
Okay, tell me where in this particular, from 359.50 to 411.05, that you want me to invite me to look at for future dangerousness.
I believe it is
no jury today. Probably no jury next week.
55, where essentially Investigator Gaither is saying to Mr. Copeland,
okay,
you're not cooperating.
Hold on one
if
second.
you don't,
you said 410.55?
I believe it's
Hey, can you give me the page references for that, please?
And it's,
I don't believe that he's saying this. I don't know.
and essentially,
No, around 410. I need to know the
What page 410?
Yes, ma'am.
That will be around page 28.
All right.
and I don't have the transcript in front of me, the state's transcript, but what the part that I'm referring to is where she says, Woody, you're not talking, you're not cooperating, you might not care about your little girl, but I do. I'm going to protect your little girl. And I think that's improper. It puts
I agree.
It improperly presents this dichotomy where the police are the good guys and the protectors of children, away from the bad guys who are out warring in the streets. And I just believe that that's an improper statement. A, it's not true, but B, it's an improper statement that invites the jurors to consider things other than the evidence in this case.
Okay, you saying that, okay, I'm looking at page 28, line 10 or thereabouts, Detective Gaither. I'm not saying everybody out to get you, but the folks that are out to get you, obviously they're coming for you. And me as a police officer, I don't give two shits about your life, but I care about your baby's life.
Right.
Copeland, I care about her life. Detective Gaither, she can't get Copeland and my life and my girl life, Gaither, exactly. So help me do this shit. And then Copeland, they out now. They out there by self. But then you're not telling me nothing. That's Gaither.
Right.
And he says, because I'm in jail. And then she goes on to say, you hear right now, and this is page 29, starting page 29, they out there by themselves, and the folks that shot at y'all are probably still out there as well,
In my most strenuous objection is just about the comments about protecting his daughter. I don't think that's appropriate.
Why does it always look like he's about to walk away? I get what he's saying. Yeah, I agree with you 100%, Texan.
All right, any other portions that you want to point?
And
Are you saying that the entirety of it, or are you just saying that particular section?
Right, that particular section about the child, and I think that fails under 403. Not probative. Again, it's the investigator talking, so she doesn't have any personal knowledge of the facts of this case. It's not really the witness presenting evidence, and again, I think it's confuses the issue, and it's likely to inflame the passions of the jurors, and it's prejudicial to our clients.
Well, if
Nope. Nah.
there was some testimony that Mr. Copeland was in a vehicle with his significant other and his baby,
Outside of his house.
and they were shot at.
Yes, this is
So they were shot at. So I'm sorry.
this interview, just for context, is 2 days after that
Yes.
event.
Wow.
So,
Wow.
you know, I mean, it's not, I mean, she's got some basis to ask him those particular, ask him or appeal to him in terms of what he, you know, what's going on in his life and her investigation. Like, don't you want to, you know, get at the folks that, or at least tell who it is that shot at you?
Well, let me.
Because she's investigating.
I'm not
correct?
criticizing her questioning of Mr. Copeland. Of course, yeah, she has the right in the interrogation room to appeal to whatever she wants. I'm just saying not every, even if it's quite honestly, even if it's decent interrogation techniques, doesn't necessarily mean the words of the officer are exposed to the jury. And that's my issue. I'm not saying that she broke any rules in the interrogation. I'm just saying that those appeals are not necessarily appropriate to expose to the jury.
Can I respond?
Okay, the volume is up on both of them.
Tell me again how it's future dangerousness.
Well, it's an improper appeal to protect the community. It's creating the impression in the juror's mind that the police are out here protecting children, and that these gentlemen, and this back and forth between Mr. Copeland and other individuals, and the state would say individuals seated back here, and this other group are putting these children at risk.
Right.
And what I'm saying is, if Investigator Gaither was on the stand and said, you know what really bothers me about these things that I've been investigating all these years, it's that these bullets come out of these guns and they're coming at children's heads. We would all jump up and say, objection, objection, that's improper. What is she saying on the stand? So I don't know why it's allowed in just because it's on a tape as an out-of-court statement. It's still making the same appeal.
I don't think she's making a general, I don't think she being Gaither, I don't think she's making an individual appeal for protection of the community. I think she's making an individual appeal to him because he's the victim of a crime, a purported crime at that point in time. So, but I've heard your argument. I haven't made a decision as of yet. State?
Yes, Your Honor. So I want to address a few things. First, this future dangerousness argument is not a proper argument for what occurred in the interview room. Future dangerousness solely talks about an open and closing argument referencing to the jury that if you don't find these defendants guilty, then this will occur in the future. That is what future dangerousness references. It has no bearing on an investigator who's trying to investigate a crime appealing to the victim as to why he should come forward with who harmed him. That is what Detective Gaither was trying to do. Secondly, Your Honor, the defense early in our trial made a number of cross-examination efforts to talk about police officers and the fact that they only target a community, that they only arrest certain types of individuals. And what this video shows, most importantly, is that she was trying to get Mr. Copeland to identify who did this. But secondly, that the police aren't just trying to arrest people. They are not just trying to get individuals charged with crimes, but yet they are trying to investigate crimes, hold individuals accountable, and make sure that those who are victims are no longer victims. And so what Detective Gaither is doing in this portion is trying her best to appeal to Mr. Copeland, who has some concern about giving up an individual, who is concerned about snitching. And that's what you're going to see later on in this interview. And she's trying to get him to identify who did this to her, who did this to him and his child and his child's mother, Your Honor. And so given one, Copeland himself on the stand says, in all these interviews, they were just out to get me. They were out to get Thug. They were out to get me. This is a complete contradiction to that, because Gaither isn't trying to get him. Gaither isn't trying to just get Thug in this interview. Literally, she's trying to identify who shot him. So one, it's impeachment by contradiction to show Gaither's, how Gaither was interacting with him. Two, she was trying to get Mr. Copeland to identify who the person was that he saw shoot at him. She can use certain investigative tools and tactics. Mr. Steele said yesterday, all day long, I want to show that this is how they investigated cases. Well, this is a part of that. This line of questioning is how they investigated cases. And when Mr. Steele says, well, I want to show these bad portions of it, then this is in contradiction to that. This is her using her investigative tools in order to get a victim to come forward. So for that reason, it should come in. And then this future dangerousness argument is not relevant for what occurred in this courtroom. So for those reasons, Your Honor, we would ask to play these portions of the recording.
All right. Anybody else other than Mr. Sharp wish to be heard on this, on the first three redactions? 35950, 40020, or 40840 to 40940, or 41055 to 41105.
That's what you're doing. I see it.
Anyone else? Mr. Weinstein? Mr. Matthews? Ms. T. Williams? Mr. Harvey? And a 105 instruction. Okay. Denied. But I've noted it, sir. I'll give you a continuing objection on that issue, okay? All right, Mr. Steele?
No, I'll adopt what was said.
All right, sir. Okay. For the reasons articulated by the state in terms of identification or impeachment by contradiction, I don't believe that future dangerousness applies for this particular portion of the transcript. I'm going to authorize or allow the state to play those particular portions over objection. I'll give you all continuing objection as to that. All right, can we move on to 41130 to 41235?
Yes, Your Honor, I'll just keep on playing from where it stops.
All right.
And Your Honor, for reference, that's page 29, line 9, through page 48, line 11.
What will that take us through?
That's going to take us through 41235.
Oh, okay, that's the fourth area of contention, 41130 through
Thank you so much.
41235. Okay. All right. You can go ahead and play it, please.
Still out there as well. Probably still out there as well. Still. Oh shit, man. I try my best, man. Cause if I help you, if I tell you anything, guess what? They make it even worse. What make it worse? Everybody, oh now snitch, now this and that and that. Bro, how you a snitch for somebody trying to kill you, the girl, and your baby? How is that snitching? I just want to get out of jail and go to my y'all. Just stay out of the way, man. I'm ready. But do you honestly think somebody else that's quote unquote the good guy gonna want to help you? If you ain't telling us like you talk about snitching and all this, it ain't about that. But as long as you out there being a part of the problem, we're gonna let you be a part of the problem. I haven't been a part of the problem. You are. You're not trying to resolve the problem at hand. And I told you the only way for you to start
resolve, to get this shit started and resolving it, is you gotta talk to her straight up. That's it. You gotta talk to her straight up. Because if you're not, it's just gonna continue and continue and continue. And I hate to see you or anybody else come up there behind some foolishness because everybody want to be loyal to the streets and everything. John Quan said, care.
And that ends at 4:12:36.
Okay. Mr. Sharp?
So, my issue with this, and again, it's going to be under 403. My issue is this: the state is clearly making the argument and trying to appeal to the jurors through their questioning, and I'm sure they're going to make arguments in closing. They made arguments in opening that witnesses are reluctant, that Mr. Copeland's reluctant. They're pointing out that Mr. Copeland says certain things when Jeffrey Williams is in the room versus not in the room. And the reality is, despite insinuations at times by the state outside the presence of the jury, that were unfortunate accusations, I think, there's been no evidence that Mr. Copeland fears anyone seated here. There's been no evidence of any threats made by anyone seated in this courtroom towards Mr. Copeland, or at least on the defense side. So here, Mr. Copeland is clearly expressing fear of being a snitch, being labeled a snitch, the ramifications of telling. But what's important here, and I'm afraid what might get lost, is Mr. Copeland is expressing fear of an entirely different group of people than the accused here today.
Good point.
He's expressing fear of the group of people that are shooting at him actively at the time of this interview, which I think the state has alleged are IF gang members. I believe that certain individuals that are not associated with any of the defendants here today were arrested and charged with that crime. So it's misleading the jury. It's confusing the issues, because I think Mr. Copeland is expressing a reluctance to cooperate out of fear being labeled a snitch, but it's not. It invites the jury to conclude that he's afraid of these gentlemen, and that's not what he's saying. And yes, I understand that we have the ability to cross-examine and those issues, but Your Honor, I just ask for you to consider the logistics of this case. The fact that the state is talking about playing, like, I don't know if we add them up, 17 hours of videos or however long of Mr. Copeland. There's it's not a typical trial where we get to just follow up with cross and clear up issues. There might be a week between when this is played and when we have the opportunity to cross-examine him about these issues and clarify some things and clear them up. And it's kind of like it's just not a smooth process. And I think that we need to do our best to eliminate any of the misleading or confusing issues from this tape, including this segment right here, which under 403, I believe that it should be excluded.
Okay. State?
Thank you, Your Honor. I think Mr. Shard is trying to compartmentalize issues, and we have to look at this case in the totality of all of the circumstances. So first things first, specifically, when I asked Mr. Copeland on the stand about Tay and about whether or not he saw Tay shooting, he said, again on the stand, he didn't do it. I swear to God, he didn't do it, or whatever his frame. I'm not quoting that as a direct quote. But also, he talked about not being afraid of snitching. He talked about the fact that whatever he said in these interviews, he was just saying it just to say it. I asked him, was he concerned about snitching, being labeled a snitch? He said, I was not. So this is impeachment by contradiction and prior inconsistent statements, both. Because I, on direct examination, asked him, was he concerned about snitching? He said, no, I wasn't concerned about snitching. They were forcing me to point out Tay. They were forcing me to do it. Gaither forced me to point out Tay. This is in complete contradiction. He literally talks about why he cannot identify Tay because he's going to be labeled a snitch. I believe this is the interview. Later on, he talks about the fact that his cousin was labeled a snitch and what happened to his cousin. So this is one in direct contradiction to that specific line of questioning. But also, Your Honor, snitching is relevant in this trial in the totality of the circumstances. Mr. Copeland, literally last week or 2 weeks ago, decided initially that he was going to plead the fifth in order not to testify in trial. To testify into trial is snitching. He has now, as a course of his conduct in the last few weeks when he has testified, is now completely contradicting everything he told police when these individuals were not in the interview room. Again, that is snitching. And here is a reason he is explaining in 2015 why snitching is a problem. So when you look at it for both the specific impeachment of my line of questioning about this interview, but then the larger conspiracy, in this case, people do not want to come in here and testify. Mr. Copeland is not the first witness. We've had Ms. Archillian Bennett, who testified that what she never talked to the police or what she told the police was a lie. But then when you come into court and have to face the individuals that you were accusing, have a different story. Same thing with Adrian Bean. Adrian Bean had a whole interview with Detective Quinn, identify Mr. Williams, identify other individuals who participated in a crime with him. But when he came into court, did not testify. So therefore, snitching is an issue in this trial. Mr. Copeland is talking about his reasons for not wanting to snitch, which is very relevant in the totality of this case. So for multiple reasons, we believe that this portion should be allowed to be played.
All right. Any other counsels wish to be heard on this particular issue from 4:11:30 to 4:12:35? Mr. Weinstein?
No, Your Honor.
Mr. Matthews?
No, Your Honor.
Ms. T. Williams? Mr. Harvey?
Judge, it can't be impeachment. This was made at a time when the witness had a motivation to lie, even after this particular event occurred. So it can't be admitted for that purpose.
All right, okay. All right, sir. Mr. Steele?
Just as the court goes through your ruling, the state's information, what they just said about
Hey, buddy,
people
good
come in
morning.
and then face Mr. Williams et al. And then are reluctant is not what I understand. I understand Ms. Bennett was upset because the district attorney's coworker was inappropriately communicating with her. I understand that Mr. Bean told another detective at the hospital when he was first arrested that he did not have information. He was told if you include Mr. Williams, then you can get out. It will be better for you. With Mr. Copeland, who's testifying, he has stated that he's been pressured by the prosecution. So this whole creation of pressure is a theory of the district attorney without zero proof. So I don't believe that should weigh into your analysis at all. I also agree with Mr. Harvey that once the reason for the fabrication or the improper influence is birthed, then under Tome, which is T-O-M-E, United States Supreme Court case, and in Georgia, Adams, A-D-A-M-S. It's also in the statute, which is OCGA section 24-6-613, because the motivation of Mr. Copeland is clear. He's in custody. He wants to get out of custody, and he's making statements. These are not prior consistent statements at all. The state is saying it's prior inconsistent statements. Sometimes they are, but sometimes they're really prior consistent statements that they wish to get in, because Mr. Copeland really is not inconsistent. He said, yes, I probably said these things, but I said them because I was motivated to get out of jail. So the state is relying on inconsistency. I believe that they're really relying on consistency, and then I join Mr. Harvey about it's not proper for a prior consistent statement.
All right, sir. Okay. In considering 411:30 or thereabouts to 412:35, the court is in agreement. At least it's a impeachment by contradiction for the reasons that the state's proffered. Whether or not the issue of snitching is relevant before the jury, and whether or not that is an issue that several witnesses have testified to would be relevant. So, but the court's primary ruling is based upon impeachment by contradiction. So that will be authorized to be inquired into. All right. Let's turn now to 425 to 425:33. Casey talking about Shannon beefing with IG people. You can flesh it out, sir.
So just a little context, Your Honor. This is after. Obviously, you know, this is after the episode of Mr. Copeland being shot at outside his house.
That's craziness.
It's also after a January 28th episode where we've heard testimony of Mr. Copeland, Demekion Garlington, and Mr. Stillwell were all in a car together, and that car was shot at, and the car stopped working, if you recall that testimony, Your Honor. So there's two different shooting situations involving Mr. Copeland, one where Mr. Stillwell was also apparently or allegedly in the car, and Mr. Copeland is, I believe, making reference to Mr. Stillwell having issues with some of Mr. Copeland's enemies on Instagram. My objection to this is that this is based, Mr. Copeland's in jail, and it's unclear how he's aware of this, but apparently he's been told about Mr. Stillwell having back and forth with these individuals. From my recollection, you know, I've been through all the discovery numerous times. I don't recall in discovery seeing any of this alleged back and forth during this time frame involving my client on Instagram. So I haven't seen any documentary proof of any of this, but so I don't know exactly what Mr. Copeland is referring to, but from my understanding of the context of the statement, Mr. Copeland is merely passing on hearsay information about what Shannon is doing on Instagram.
Okay.
Mr. Copeland does not have access to Instagram, obviously, as he's making these statements.
All right, can I hear it, and what transcript page is this from?
It's going to be page 47, but page 47, line 9 through page 48, line 15. But I do think for context, we need to start at 424, which is going to be page 45, line 25. Page 45, line 25.
Page 45, line 25?
Yes.
Okay. All right, go ahead and play it, please.
I did see no face. It did. When I see him jump out the car, kind of favor somebody. Who? The boy that was showing at my house.
Who? Who you know to be driving that silver Bonneville?
I could never picture that. That's something I could never get.
So who do you favor?
Say,
Your friend Tay? Which Tay?
well, you are my partner at the moment.
Where you from?
Simpson.
You from Simpson? How can I find Tay?
He on his Twitter arguing with Shane.
He did what?
He's on Twitter arguing with Shane.
He on Twitter arguing with Shannon. This recent?
Yeah.
When?
Right before y'all came and got me, I was just on the phone with my baby mom. She just told her.
So him and Shannon on Twitter arguing.
They been
About what?
me saying it. You still alive, 'cause we miss you.
You said a lot because we miss you? Like they miss maybe shooting at you? When did you see this person? Like before the incident the other day with your baby? Before the incident with you and your baby, you said the dude was shooting at my house. Which incident are you talking about? You said the same boy that was shooting at my house. Okay, which?
And you're right within that 425, 49.
Okay. Yes.
So it's in, I heard it, and I'm assuming Your Honor heard it. He says Tay, and they're trying to figure out who Tay is.
Which
And
Tay?
The Tay, I don't know which Tay at this point.
Okay.
There's a Tay that allegedly shot at Mr. Copeland, or that's the state's theory, and Mr. Copeland is saying Tay, but he's not identifying Tay, and he says something about that Tay is having an argument with Shannon on Instagram, and then he was like, when is this happening, is what Investigator Gaither asked, and Mr. Copeland says, essentially now, or when I got locked up, and he said, that's what my baby mama told me. So it's clear his source of information is someone else who's telling him about this alleged internet argument, and he doesn't have any personal knowledge of it.
All right, sir.
It adds absolutely nothing to the context of this statement, other than it brings in hearsay evidence about my client, which I object to.
All right.
You're right, the section about Twitter, we won't play, we'll just pick back up when Detective Gator's trying to clarify, like they missed you, when was he shooting at you? Try to clarify that question, but we will take out, I think it's probably about 425.
425.31 to what?
No, 425 to 425.
Okay, 420. 425.20.
No, 425.00
Yes, ma'am.
to 425.
Again, the only reason we're doing this is because the
32.
state couldn't
That's what you
control
said
the
you're gonna
witness.
take out, because that talks about the Twitter conversation. All right. Mr. Short, anything else from
Yeah,
that
we don't know where
particular
love
time
at,
block
James.
that you
We
wish
don't know
to
where
be
love at. We need love.
omitted? All right. Any other counsel wish to be heard about anything from 425.00 to 425.33? Mr. Weinstein.
No, Your Honor.
All right, Mr. Matthews.
No, Your Honor.
Ms. T. Williams. Mr. Harvey. All right, Mr. Steele. Okay, all right. So the state will be directed to omit that particular portion. The rest of it can be played. All right, let's move on to 6, and that would be.
He sounds so deflated.
This next is it's a
Hold on, let me just frame it right quick, sir. 438.35 to 438.40, and you've indicated that Casey saying that he has not hung out with Shannon Lil D since they shot the car. Confusing under 403 is a pronoun they is meant to refer to people shooting at Casey, Shannon Lil D, but could be misconstrued.
Right.
Okay.
So essentially, they are asking about when's the last time he hung out with Shannon and Lil D, who's Demekion Garlington. And he says, not since they shot at the car. I think any reasonable interpretation of that, based on someone who's spent hundreds, probably thousands of hours reviewing the discovery in this case, which I have and the defense counsel has, any reasonable interpretation would mean he's referring to is the people that shot at him, Shannon, and Lil D in the car on January 27th, I believe it was, the day before the statement on the 28th. However, the jurors have not gone through all the discovery 10 times over as the defense has. So they have limited knowledge of everything. And when you listen to the statement in a vacuum, the reasonable interpretation is he hasn't hung out with Shannon and Lil D since they shot at the car, which makes it seem like Shannon and Lil D were shooting at a car. It's confusion of the issues. It's likely to mislead the jury. And again, Your Honor, this is another one of those things I said earlier. This is not a normal trial. Yes, theoretically, first of all, there's no need to bring this confusion into this trial. So there's no prosecutorial need for this little excerpt to be played. But sure, theoretically, we could clear this up during cross-examination under normal trial circumstances. But when this is played, there's going to be several days in between that time where the jurors are likely to have in their head, if they're scrutinizing every line, oh, wait, Shannon and Lil D were shooting at a car? You know, and that's going to affect the way they look at my client. And when, in fact, we can just clear that up at the time of him saying it by deleting it, as opposed to me having to come back days later and try to clarify and draw everyone's attention back to this incident and this statement. So I just think under 403, to avoid confusion of the issues, we could easily just redact this little segment and clear up any potential confusion.
Your Honor, before I even play it, the state understands what Mr. Copeland is talking about when he says when they shot at the car. The state has no intention of alluding that the they is Mr. Garlington and Mr. Stillwell trying to shoot at Mr. Copeland. And when I read this portion, I'm going to play for the court the entirety of that section, because I think in order to understand this section in context, you have to start at 438:14, because there's already evidence, or will be before this video is played, that there was a shooting on the highway in which Mr. Copeland was involved in. And the state in no way, shape, or form intends to infer that Mr. Demekion Garlington or Mr. Stillwell was trying to shoot at Mr. Copeland. That's not even something we thought of. So we'll play the whole section so you can hear it in context.
Fine. Can I get the page references?
Yes, Your Honor. We're going to start at, it's going to be roughly page 64. And I'm starting at 438:14, so it should be around line 2 on on page 64, line 2. And it will go through page 65, line 1.
All right, madam. All right, let me hear it, please.
In that fucking river with them, period. This is what is going on. There's two people I be with. They're going to be Shannon and Lil D. When I'm making with Shannon, me and Lil D together all the time. That's all. That's exactly. Yeah. There's me and him together all the time. Them only two I do with. Since they shot their car, I've been in the house with my baby mama. If I ain't in the house though, we don't got to argue, and I don't call Quay. Quay don't can't pick that up, and we just rolled around here.
So we stopped it at 4:38:46. So in context, he's talking about the last time since they were shot at in the car. Well, before we played this interview, we would have played the January 28th interview where he's going to talk about the fact that they were shot at in the car in January 28th. And so when you read those two in conjunction with each other, I believe the jury will understand that he's saying since they got shot at the car, I've been in the house, given the full context. And again, the state will not infer that the they is Demekion, Mr. Garlington, Mr. Stillwell shooting at Mr. Copeland.
Okay.
When I said the defense attorney's been spending a lot of time with this case, also the state has. I mean, they have a background understanding. Both sides have a background understanding that's through discovery that's deeper than what the jury has at this moment. And that this line adds nothing to the understanding of the case. But, you know, I just listened to it again. I was thinking maybe I missed something. He says there's no discussion of other people shooting at the car. They say, when's the last time you hung out with Shannon and Lil D? Not since they shot at the car. I mean, it sounds like my client shot at a car.
Well, it has to be taken in context because the jury's already heard about some purportedly shooting. Okay.
Yeah, but
I understand your concern under 403. I respectfully disagree at this point, but
okay.
Because I don't think it would confuse them. But anyways, anybody else wish to be heard on this issue? Mr. Weinstein. All right, Mr.
Good to see you,
Matthews,
Foster.
Ms. D. Williams, Mr. Harvey, Mr. Steele. Okay, all right. I'm going to admit it are allowed to be played over objection. I still give you a continuing objection, okay? All right. Let's turn to number 7. And number 7 is 60325 to 60605. And you...
By the way, it's page 155, line 1 through 156, line 2. 155, line 1 through 156, line 24.
Okay, Mr. Short.
They haven't even done the phone calls yet, Sarah. I don't think there's any hope that this is going to go. I mean, this might be the whole month of July at this point. They got still, apparently they had multiple hours of video evidence, plus they got the phone calls. I think the phone calls like 90 minutes worth of phone calls. To me, this is a terrible look.
All right, let me frame the period. It's 60325 to 60605. It alleges Casey talking about Kel shooting and at some dice
At a gambling spot.
Gambling spot.
Which I believe under the state's theory is kind of one of the incidents that's the genesis of everything, of the disagreements between the groups. And my objection is that Kenneth Copeland is basically telling the police that Kel shot up the gambling spot, but even in his own statement, his identity.
No living being should ever eat processed food for every single meal of their life.
So it's not that he wasn't there, but from my understanding of his statement, he didn't know, no one knew who shot up the gambling spot. No one identified Kel, who's Kelvin Watts at the time. But afterwards, apparently, according to Mr. Copeland, Kelvin Watts told his girlfriend, or a girl that he knew at the time, whose name's Trevia, about what had happened, and apparently made some confession, according to Mr. Copeland. And then Trevia tells Kenneth Copeland. So it's double hearsay, and certainly even if Kelvin Watts to Trevia would fall under a hearsay exception, Trevia to Kenneth Copeland would not fall under a hearsay exception. So it's hearsay, and he doesn't have a basis of knowledge, and we would object to its admission.
James, don't get him started, bro.
All right, State.
Don't
Your
get him
Honor,
started. Please don't get him started.
The information about the gambling spot has already come in based on the January 11th interview in which Kel discusses, if not January 11th, February 20th, but the two interviews that have already been played before the jury. Mr. Copeland has already said in both of those interviews that there was this incident at the gambling house in Lakewood, and that it was Kel who did it. And more importantly, when he met with Kel at the Cascade skating ring, maybe the next day after this gambling incident, that he talked to Kel about the shooting at the gambling house, and that it was during that meeting at the Cascade skating ring that Kel got on the phone with Mr. Williams, and Mr. Williams asked for Kel to pay for the window that was shot up at the gambling house. So one, the evidence is already before the jury about the gambling house. How we get to who told him is irrelevant, because it was the effect on the listener, meaning Mr. Copeland, that once he gathered this information, he's using this to try to squash the issues between Copeland and Kel. And so when he's relaying to Detective Gaither the beginning of the conflict between him and Copeland, he's just now reiterating how he got the information that Kel did it, and what effect once he had this information with using this. So who told Mr. Copeland that it was Kel is irrelevant to the sole fact that he thought it was Kel. That was kind of the beginning of their issues with each other. And as a result of knowing that it was Kel who did the shooting, Copeland in turn confronts Kel about this shooting. And during the course of his confrontation of Kel, also had a conversation between Kel and Mr. Williams about the shooting that occurred. So this portion as to how he found out it was Kel is not, while hearsay is really effect on the listener, but this is already information that's before the jury. But it's important, Your Honor, because let me say this, that defense counsel is arguing that Copeland consistently lies. What this shows is that Copeland's giving the same series of events to multiple different investigators at multiple different interviews. And so that shows that at least back in 2015, when he's recounting his history with him and Kel, he's telling different investigators these same series of events that occur leading up to the murder of Donovan Thomas. But I'll play the section for you if you want to.
All right, sir. Yes, ma'am. Go ahead.
And I'm going to start at 6:03:22.
But that's what it was about. Then they got mad. Ladie got jumped in the club by NBC. They tell Ladie, we ain't got you because you be with them. They asked Ladie, why they ain't got you?
You don't got too much shit going on. And don't know nobody know why.
It was, no, but the whole time come back on Kevin, because this is a gambling house we go hang it and gamble. We go down and gamble. We come out the league. Kel, I'm in the bush. Kel, Stewart, and they never mentioned the third person name. And the bush, they started showing me them. They shot so many times. Shit, I was glad they were like, huh?
Okay, well.
In Lakewood. They shot so many times. They shot down to everybody's car. But they missed everybody. They graded one person across the back. But when police came here, left. Co-people left. But they were killed. But that's the same like NBC jumped on Lil D. So they did that and make it seem like NBC did. But I go over and going home. I stayed out about 2 or 3 years. So I was telling them like, damn, bro, y'all ain't gonna come out there. Y'all trying to kill a nigga. What's up, bro? And they like, hell nah, bro, you tripping? Like, bro, we ain't see that y'all did with one of the NBC niggas. Like, bro, we ain't got no problem with that, bro. You feel me? Y'all jumped on Lil D. Lil D be with me, bro. I'm on the stage. I was like, nah, bro, y'all tripping, bro. In my palm, bro, nah. They keep trying to get in each other's face. But nah, the next thing you know, Big Boo came up there, and one of them niggas on Swarm, grabbed the D off stage, started jumping on the D. I ain't know it was a D. I'm thinking they wanted them jumping on them. So I walk out the club, see the D, him got the shot in the hand, and he bleeding and shit. Oh, what happened to you, bro? And he couldn't talk. He was like, and I was seeing the hammer, but damn, they shot you too. So he went and got hammer now. He went to the hospital. So I had to tell him mama what happened. And Pinky went down there with him. Goddamn, the next night we at the gambling house. They ain't not putting no pictures. We in that gambling. They take pictures and shit. Then he came out there and shot at it. We found out it was killed. He had got into a Gucci Red. And she was talking to them. She came back and told her, like, man, they were killed and shot at y'all. Mixing like they did. Because they shot at it and they went and shot at Monday spot. Monday we got into it with the NBC name. They bumped, boom. They how they fight started. They went and shot at their house on Metropolitan. Shot the house on Thurlow. So yeah.
And it ends at 6:06:07.
So to put a little context to what you just heard, this gambling spot was shot up, according to Mr. Copeland. It was assumed that it was people from a group called NBC, because according to Mr. Copeland, Mr. Kendrick had gotten into some sort of dispute with someone from NBC around that time, is what Mr. Copeland's saying. I don't know if that's true or
Mr.
not.
Kendrick or Mr. Garlington?
Mr. Kendrick. I think he says Monte. I'm assuming Mr. Kendrick. Maybe someone else named Monte. And I don't know if any dispute occurred. But what he's saying is it was assumed it was NBC. And then through hearsay, it came out that it was Kel. Through hearsay, through trivia. And so our stance is that's hearsay. Effect on the listener is much narrower an exception to hearsay than the state's been putting forward in this case. Throughout this case, they've been relying on effect on the listener quite a bit. I don't believe that it's quite as easy to get around the hearsay rules under just saying effect on the listener. And his knowledge, he's giving a historical narrative of this event, and his knowledge of who committed the event or committed the act is based entirely on hearsay. So
what about the issue that we've heard testimony already about the gambling
then
house?
It's cumulative.
Then the shooting of the gambling house.
Well, if we've allowed that in the past, then that's on the defense counsel for not flagging that. But at this point, it's cumulative if it's come in already.
I believe it's already been testified to. In fact, I think Mr. Copeland earlier in his direct he's testified about that on the stand, about the shooting of the gambling house and this kind of historical perspective.
At this point, then it's cumulative, and if collectively we have missed it in the past, we're flagging it now.
Okay, all right. Any further argument, Mr. Weinstein?
No, Your Honor.
Mr. Matthews?
No, Your Honor, just a thought.
Ms. T. Williams? Mr. Harvey? Sir? Turn your mic on, sir, please.
I want to adopt what Mr. Shart said with regard to the effect on the listener. Effect on the listener is usually most often used to as evidence of motive. It has not been used in that sense, and therefore it has been abused and continues to be abused as the basis for the admission of these clearly hearsay statements. So, for example, in Gates versus the state at 298 Georgia 324.
One more time, Gates.
Gates 298 Georgia.
All right.
324.
Yes, sir.
There were text messages admitted that were sent to the defendant's girlfriend, not for their truth, but for the effect on the defendant in establishing motive for a murder. That's the usual basis upon which hearsay statements are admitted for the effect on the hearer. That is not the case here. This is not the defendant. It doesn't establish motive.
What do you think Young Thug is doing? What is he doing?
Adopt and expand Mr. Shart's reasoning.
All right, sir. Mr. Steele.
Nothing to add.
All right, sir. Excuse me.
I agree, Mitch. I think you hit the nail on the head. There's a lot of missteps in this case. But RICO is meant to bankrupt you and to find the weakest link. So you throw everybody in RICO and then offer plea deals to the lowest until they get to the highest. Hey team, real quick. I don't know what they're doing. So I just went back to, cause I kind of started a few seconds late. Glanville never addressed the whole Supreme Court immediate review. He didn't address it at all. He literally comes in, he does roll call. He says we're going to try to get through the February 21st hearing. And the next thing you know is he calls Ms. Hilton up. So he never actually addressed it. So I don't know if that's common, because I guess it wasn't to him. It wasn't addressed to him per se. So we didn't miss anything really. We might have missed like just again, like 5-6 minutes of the roll call and checking on people, and said he got an email from Shard. But that was actually it. Everything else we caught. So just letting you know that. And I have no idea what they're doing at this moment. It's not on mute though, I'll tell you that much. Thank you so much. There's almost 200 of you all watching, 100, so almost 50% have liked the video. I really do appreciate that. Thank you so much. So I don't know, back to the point, I don't know if he's supposed to say something about the appeal for immediate review or whatnot, or is that just on the Supreme Court to make a comment on or whatever like that. Hopefully they'll decide sooner than later, because all of this is really for naught. All of this is just really window dressing on the Titanic, because clearly the issue at hand is that this case probably needs to go to mistrial, in my humble opinion. Yeah, literally, they jumped right in. So there was with both feet. So I have no idea what they're doing there. Okay, can somebody tell me why Hilton is sitting where she's sitting, but the dude in the little taupe colored suit is on the right? Why is he over there? And what is Hilton listening to? You see her grooving? She's listening to something and she's enjoying it. And she is grooving out to it, whatever it is. I ain't mad. Hey, good to see you so much retired. Thank you so much for stopping by. Right, once you come in, everything gets quiet. It's hilarious. Oh, maybe that's it. It's just above it. Above his head. It's over my head. Absolutely. Yeah, I don't know. That's a good question, though. I mean, a good point. Likes the RICO from prosecuting campaign dollars. Man. Oh, yeah. I did read this last week. Good point. You think she listened to the new Little Woody? I like it. I should cue that up. Okay. I'm just like, but it would make sense, in my opinion, for her to be sitting where the guy is, because she's always getting up. She's always getting up. So I get your point, and maybe that's it. Maybe that's it. I got you. But why would she not want to change? That's all. She put earbuds in. Did y'all see her? I saw her with her phone. How comical would that be? Somebody says she grooving out to Young Thug. And I think I see earbuds in her ear. I think I see cables going to her ears. Or might be hallucinating. Yo, that Marlon Wayans was so inappropriate, James. I'm like, yo, how are y'all okay with this? That thing, it was out of line. Like, I meant out of line because the seriousness that they want us to have from a comedic standpoint, he was fine. Is the fact that they're going to turn around and want us to be serious about it. And remember, Fonnie Willis, and most of y'all might not know Maybe you do or you don't know what James is referring to. James is referring to the Marlon Wayans skit he did with Nathan Wade. Remember, Fonnie Willis said that the other team, the Republicans, white males, are the ones that are over S-utilizing her and other black women. But literally, Marlon Wayans is making some pretty crass jokes about her and Nathan Wade. Where were the white people? Where were the white people in that? So I think, let me pull that back up again. I didn't even want to do it because it was so inappropriate. Like, dude, I'm already skirting the line sometimes with this court case. But it was just out of pocket. And I'm like, how is that going to help? Like, how would that interview, how would that skit help people take Fonnie Willis and Nathan Wade seriously in any regard? It just seemed wild. Because I guarantee you, if Trump did something like that, they would have all kinds of problems. But like, why is that okay for him? All right, good commentary going on. Yeah, I have no idea what Judge Glanville is doing. He says she definitely check out the track from We Watch YouTube. Beat the Rico. Well, apparently, according to Marlon Wayans and Nate, people do, which is totally out of pocket, but yeah, I don't know why. I have no idea what's going on. Yo, that's it right there. The judge is checking his retirement account. He's like, how many more days I have? How many sick days I have? Can he get to? Bless her heart. Court reporter is very bored. Bless her heart. She seems like a nice lady, though. All right. Well, while they're doing that, let's pull this back up. Watch, as soon as I get done, as soon as I do this, they're going to start talking again. I guarantee you. All right. So let's go look at this end of this. We were on page 14. So this is the document seeking immediate recusal of Judge Glanville that was filed by Weinstein on yesterday. Upon belief and information, Copeland's statement that he would lie to the DA, we already talked about that, stated that he would not be prosecuted as a sworn witness, Copeland, if he were to lie on the stand. Important Brady material that has yet to be provided to Kendrick, which is Yat Gotti. Let's keep going. Sworn witness Copeland also stated to ADA Hilton that he would testify that he killed Big Nut. Important Brady material that has not been provided to Yat Gotti. In response to sworn witness Copeland stating to ADA Hilton that he would testify that he killed Big Nut, ADA Hilton told Copeland that she would prosecute him for perjury if he testified that he killed Big Nut. Important Brady information that has not been provided to Yat Gotti. That's craziness. That has got to be absolutely craziness, because if he did confess that he did it, that would totally turn this trial on its head. It would turn this trial in a whole different direction. Catch up, make sure. Yeah, they're doing nothing in this trial. Wow. Okay, I have no idea what they're doing. All right, let's keep going. 3 troubling facts not only implicate Glanville in an impermissible effort to join forces with the state to coerce Copeland to testify, but also demonstrate an illicit effort to repress Brady material that should be provided to Yat Gotti. Attorney Okay, they're taking a comfort break. All right, he called a comfort break. You can hear his dog moving. He's taking his dog out. But he didn't change the monitor. He didn't change the camera. All right, let's keep this going. Yeah, he left the camera on. He didn't move it like he usually does. So we can see everybody now. Interesting. Kayla Bumpus by and through. Let me just mute that so it's not just playing in my ear. Okay. Kayla Bumpus, by and through her counsel, filed a motion to quash order to show cause and motion to recuse, issued example D, on Friday, the 14th of June, which subsequently supports the Weinstein affidavit as a participant in the ex parte proceedings. Bumpus' firsthand account of the misconduct is credible. Okay. The facts attorney Bumpus asserts are as follows. On Monday, 10 o'clock on June 10th, at approximately 8:30 a.m., Mr. Copeland and his lawyer, Kayla Bumpus, were escorted to the court's chambers and conducted an ex parte proceeding regarding whether Mr. Copeland would testify, example D. Those present are the substantive portion of the ex parte proceedings were Glanville, Copeland, attorney Bumpus, lawyers Love and Hilton, members of the court security team, and deputies, 2 investigators from the Fulton County District Attorney's office. That's crazy, and a court reporter. So that's the 14 people that, if you heard Bumpus, I think she was on Talk That Law, and she said there was 14 people in there. That would make good sense right there. All 14. All right, let's keep it rolling. In chambers, Glanville asked Copeland whether he was prepared to testify. Copeland announced that he planned to assert his Fifth Amendment rights. A conversation among the parties ensued regarding Copeland's understanding of immunity, how Copeland thought he may testify if he did not invoke his Fifth Amendment, and certain facts in the case. Once Copeland learned that he could be held indefinitely by Glanville if he refused to testify, not just 2 years as he initially believed, Copeland yielded. And that's probably why he came in there all hot like a firecracker, because he got shined up by them back there. Okay, that makes sense. Copeland cautioned that his testimony would be a lie. So they pressured him to testify, and then he says, well, what I'm going to say to you all is going to be a lie. All right. Now, that's probably why they're leaning so heavy on all of this investigator interrogation videos. So I'm wondering, can the defense call Woody up? Maybe they can. Even after all that's done, could the defense call Woody? I just hope this thing ends, because it's just such a dumpster fire. It's clearly poorly run. That's unequivocal. Point 3, events in court about the time of the secret ex parte proceedings. On Monday, June 10th, all defense counsel were present in the Fulton County Courthouse at about 8:30 a.m., admitted entrance into the courtroom 1C, and seated within about 9 a.m. So they're there. We're like, hey, we were present. We were here. We got here on time. No getting chastised and the right papers. Between 11 a.m. and 11:30, Glanville took the bench, announced that Copeland was prepared to testify. Sensing something amiss, attorney Brian Steele, on behalf of all defense counsel, specifically asked Glanville about the reasons for the delay, providing Glanville with an opportunity to reveal that he had an ex parte proceeding that had occurred and the content of the proceedings. Failing to provide any substantive response, Glanville obstructed Steele's attempt to discover reasons for the delay. Okay, I don't remember seeing that, but I totally believe that happened. So let's keep rolling. I would probably just look back on that day. That afternoon, when Steele's understanding of the morning events was presented to the court, Glanville shifted focus away from the extraordinary allegations to the source of Steele's knowledge. I do think it's interesting. Steele still hasn't said how he learned this, because Steele has some pretty in-depth knowledge. So it's not just a matter of, hey, I heard that y'all had an ex parte meeting. No, you know a lot about it. Glanville shifted focus away from the extraordinary allegations to the source of Steele's knowledge of the misconduct. When Steele refused to divulge the information, citing Rule 1.6, Glanville held Steele in criminal contempt and sentenced him to 20 days in incarceration. Let's just keep going. On June 12th, 24, Kendrick Yak Gotti filed and presented to the court his motion to recuse. During the 10-minute hearing on the motion, Glanville mischaracterized the motion as a complaint regarding his previous rulings. He does say that a lot. Now that I think about it, he does mention his rulings a lot. Glanville ignored the subject matter of the motion and the affidavit, which was an accusation that on June 10th, the secret ex parte proceedings was, one, in violation of at least Section 2.9 of the Georgia Code. I'm not going to read all these. And two, a violation of Rule 211 in the revised Georgia Code that says generally that judges shall disqualify themselves in any proceeding in which they are impartial. Their impartiality might reasonably be questioned. Oh, that's a wrap. If that's in the Georgia Code, it's a wrap. Well, what else are you going to do? How's he going to argue that, sir? During the June 12th, 2024 hearing on the motion to recuse, Glanville refused to conduct the timely analysis required by the USCR 25-3. Despite Weinstein bringing it to the court's attention, Glanville refused to make any findings of the summarily denied the motion. Weinstein requested at that time a certificate of immediate review. That request was denied, foreclosing an opportunity to appeal Glanville's ruling. Glanville stated that an appeals court could look at his denial at the conclusion of trial. And I think we talked about that already. Just that, hey, so basically he said, hey, yeah, if I made a mistake, let the appeals court figure it out when they get back. That's craziness. On the 14th, Glanville issued an order on motion to recuse Chief Judge Glanville, attached Exhibit B. The order formally denied the motion. In that order, the court did make findings, though not in timely fashion required by USCR 25-3. The court found all three prongs of the 25-3 satisfied, and that the analysis should have been stopped there. Exhibit B, pages 3-5. But Glanville did not. Applying the wrong standard and reaching a wrong conclusion, Judge Glanville found that the court finds that the cursory review of Weinstein affidavit submitted to the plaintiff's support for their motion contains assertions of fact to support the allegations of bias and impartiality. However, while these assertions were made to support the defendant's allegations against Judge Glanville, there is a notable lack of evidence to support the assertions. This is the first of three motions to recuse denied by Glanville. I mean, they make a great point. I don't understand. I would love to know more about this, because I'm just like, how is this okay? Okay. All right. I like it. Okay. I see y'all. All right. So those people are just stopping in. We are watching the Young Thug case. What day is this? This is day 26. 96, please forgive me. We're watching Young Thug case. They're going through Little Woody's interrogation videos, redacting and excluding certain things that they find useful or not useful. They were doing a comfort break. Now, I did recognize that Judge Glanville didn't give a time for the comfort break. So I don't know if he said 5 minutes, we're back at a certain time or what. He just had a comfort break that I heard. But besides that point, we're just going over the writ mandamus that was filed on yesterday. Let's keep going. Argument and citation to authority, standards for granting writ mandamus. All right, this is why you should follow this writ mandamus. Under Georgia, all right, this court has those powers necessary to aid in the jurisdiction of its jurisdiction, including the power to issue a process in nature of mandamus and injunction. Allows parties to seek mandamus to compel a due performance of official duties where a defeat of legal justice would ensure from the failure to perform or from improper performance, and there is no other specific legal remedy for legal rights. Okay, make sure I didn't miss anything. Okay. To compel removal of a judge, a petitioner for mandamus must show that a sufficient amount of motion to recuse has been filed and that the motion has not been denied after assignment to a separate judge. So they haven't gotten it to a separate judge. So there's the first problem. To preclude mandamus, the alternative legal remedy must be equally convenient, complete, and beneficial to the petitioners, please forgive me. When a trial judge is presented with a recusal motion and an accompanying affidavit, the judge must temporarily cease act on the merits of determine immediately whether the motion is timely, okay, whether the affidavit is legally sufficient, whether the affidavit sets forth facts that, if proved, would warrant the assigned judge's recusal from the case. Okay, I can understand that. Glanville, I'm just going to keep reading. Glanville following filing and presentment of the motion to recuse on June 12th failed to make the required determination under USCR 25.3. Glanville summarily denied the motion, relying on a mischaracterization of Weinstein affidavit as a complaint, but a ruling made by the court instead of recognizing it as a list of indictments of judicial misconduct by Glanville. Glanville curiously clings to Baptiste versus State as supporting his contention for that the Weinstein affidavit does not merit recusal, but there is no support in Baptiste for this position. In fact, Baptiste supports petitioner's position that Glanville's bias is of such a nature and intensity to prevent the defendant from obtaining a trial uninfluenced by the court's prejudice. Glanville's order on June 14th, which was last Friday, contains a critical error of law. The law requires that when making a determination under US 25.3, the court must consider whether recusal would be warranted, assuming that any of the facts alleged by the affidavit are to be true. A judge is not allowed to pass on the truth of the allegations in the affidavit, State versus Fleming. And we'll keep going. Instead, Glanville properly found that the Weinstein affidavit contains assertions of fact to support the allegations of bias and impartiality. We know that, which by law should have ended his inquiry. Glanville must then refer to the recusal motion, to a neutral judge to decide the merits of the motion. I don't understand how he's not doing this, pursuant of 25.3. All right. Thanks so much, everybody that stopped by. I still don't have anything in. Let me just double check, make sure. No, the case is not returned. Your boy needs to get YouTube Premium, and we're still waiting. So, okay. Let's make sure we're ready. Okay, cool. Glanville's factual review of Weinstein's affidavit is particularly astonishing, given that Glanville has reportedly refused to give defense counsel access to the transcripts of the secret ex parte proceedings. We got some movement. We are on page 24. We're almost done. Oh, we actually are done. Because this is just notes. Okay. We are on page 24. Remember that, Jason. I don't know. They moved, but then they stopped. They got us over there and then they tricked us. Okay, new poll is going up. All right. Make sure I'm y'all like to get on me if I get behind. So let's see. Yeah, I'm caught up, man. It's just nothing's going, nothing's popping. Okay, I'm ready. I'm ready, y'all. I'm ready. I'm telling you. All right, all right. I dropped a new poll. What time do you think they're going to recess today? They're going to recess at lunch? Do you think they're going to go to 2? They're going to go to 1? When do you think? I think. Okay. A whole hour, James. A whole entire hour. You are correct. He's already back. So I don't know if they just didn't turn, maybe they didn't turn the cameras on and the mic on. There we go.
You said you had a response to Mr. Harvey's comment.
Yes, Your Honor, very briefly. In looking at Gates, Your Honor,
Drop a one in the chat if you can hear.
Which they talk about the effect on the listener. Yes, this was a murder case, but what it says, and this is in Division
2.
2.
I have it up.
Yes. And when you read the fullness of it, it says, for a statement of constitutional hearsay, it must be offered in evidence to prove the truth of the matter asserted. And it cites the statute. Here, the declaring statement at issue was, you're ever lonely, you can call me. The text message sent along with the naked pictures was not offered to prove that Gates' girlfriend could in fact call or had permission to call Wilson if she were lonely. Rather, the text messages were offered to show its effect on Gates and in this case, his motive for committing the murder. An utterance may be omitted to show the effect on its hearer. See also Miller v. State, 275 Georgia
Shout
32.
out to Texan. Thank you so much.
For such a purpose, the statement would not be hearsay, as it was not offered for the truth of the matter asserted, but for the effect or lack thereof on the hearer. As such, Gates claims that this evidence was inadmissible because it was hearsay without merit. Here, again, Your Honor, learning about the fact that Kell shot at the gambling house what Copeland took with that information is he confronted Kell about it. They had a discussion about not just the gambling house, but all their other issues that they had with each other. And then furthermore, during this interaction, which was, I believe, the next day after the gambling house or some time later, Mr. Williams then speaks to Kell about that shooting that happened at the gambling house, and specifically
Where is this
about
gambling
paying for the
house?
window. So again, Your Honor, it's not about what, and I believe it's
Where's
Gucci
gambling
Red. I think Mr. Shar said that it was Trivia who said it, but I believe he said Gucci Red told us it was Kell.
Red.
That information is what he used to confront Kell about about what happened at the gambling house. So that's what the state wanted to add.
What's your response to the defense's assertion as well as cumulative? Because it's been testified to.
Because, Your Honor, defense counsel assertion is that Mr. Copeland lies about everything. And so what his reiteration of this incident shows is that not just in the February interview, not just in the January interview, January 11th, he talks about it, I think, briefly in January 28th and February 20th, that he's reiterating these events to different investigators to talk about the history of what has occurred between them. And if he's such a liar as they want to purport him to be, then he would not be able to recount this historical perspective to the detectives that he is meeting with. So while he is repeating the story, he's repeating it to different detectives at different times to show that he is at least consistent with the historical events that lead up to Donovan Thomas's murder.
All right. Okay.
But remember, Little Woody said that he was lying.
All right,
He's the one.
counsels, I've had an opportunity to consider your arguments as well as take a look at Gates 298 Georgia at 324, as well as Garner versus the state at 342 Georgia Appeals 824. Both of them stand for the same proposition about effect on listeners. So I'm going to permit that to be the inquiry area of 60325 to 60.
So, I tried a new dry cleaner. Luckily, I didn't make the same mistake with my water heater. I brought in the experts. They're a perfect fit. Don't say it.
Call the Pink Plumber and get $50 off any plumbing repair. Call 404.
All right.
I'm going to get that fixed. Don't worry about it, y'all.
Defense counsel.
I'm going premium. I'm going premium.
Let's move on to 8. I believe 8 is 6/19/20 through 6/20/20. And I believe that is Casey being reluctant to cooperate in the shooting investigation where he's a victim. He says he's concerned they will put the discovery on IGS or Instagram.
Yes.
Okay. Can you give me the page references, Mal?
Yes, Your Honor. So page 173, line 7 through page 174, line.
Okay. All right. Mr. Sharp?
So, Your Honor, here is another example of Mr. Copeland stressing the social ramifications of cooperating in this investigation. Again, when I say this investigation, I'm referring to an investigation against people that shot at him allegedly outside of his house while holding his child.
That's crazy. That's so crazy.
We get into this, it's almost bolstering. It is bolstering where he's showing a fear of testifying, but again, it has nothing to do with these gentlemen. It has nothing to do with the investigation of these gentlemen seated in court today, but it has to do with an entirely different group of individuals from that are allegedly associated with an entirely different group. So it has no relevance to this case. It creates the impression that Mr. Copeland is universally opposed to cooperating, universally fearful, universally has been threatened and feels threatened. But the reality is he's expressing fear, reluctance, and all the rest regarding an investigation of an entirely different group of individuals. And it's likely to confuse the issues. It's unfair prejudice towards our clients where there's absolutely no evidence that he's been fearful, that he's been threatened by any of these gentlemen or anyone associated with these gentlemen. So we would argue that it should be excluded under 403, 401 and 403.
All right, madam, can you play it, please?
And Your Honor, I'll start at 6/19/40.
You remember my name? In that car that's gonna put them there. Like you worried about the wrong thing. Like, I'm worried about when you get locked up and you get a skirt back and see I circle each picture and put my name on them. You're gonna send it out to the screen and be like, I done told on him. And they're gonna put it out on Instagram and Twitter and they're gonna tell everybody. And then guess what? They're gonna start like, then I'm gonna be just like what then? Nobody won't be around. So you worried about your reputation as opposed to your life and being a free man? It's up to you. I don't want to go back and forth. You gonna do it, Woody, or you not?
And Your Honor, that's the conclusion at 6/19/44. And Miss we started at 6/19/06. And Your Honor, may I respond?
Yes, ma'am. What's the state's response to Mr. Shard and the defense attorney saying that violates 401 and 403?
So again, Your Honor, one, this is a impeachment by contradiction. Again, in court, Mr. Copeland has said repeatedly that they forced him to pick out Tay, and that he was not afraid of snitching or telling the police who did it, but that Tay did not do it. So one, this is a contradiction to both of those assertions that he made in court. Here, again, for the totality of the case, Mr. Copeland, back in 2015, and we believe even now, does not want to come to court to testify against whether it was Tay or these individuals. So this shows, one, he contradicted his testimony as to what he did back in 2015 as it relates to Tay. And then two, it shows not that he's fearful that anyone's going to harm him, because the state has never asserted that any of the defendants were going to harm him. What the state has asserted is that he does not want to come and testify against them. And this is a prime example of that. So for those two reasons, we believe that this portion should come in. Additionally, Your Honor, when Mr. Shar says this had nothing to do with this case, that is not true. What Mr. Copeland is talking about in this interview is a retaliatory shooting that occurred as a result of Donovan Thomas being murdered. So again, putting this all in context, Mr. Thomas was shot and killed on January 10th. Over the course of about 6 to 8 weeks, there are multiple shootings. We went over that yesterday, Your Honor. And one of the final shootings was on February 19th when these group of individuals that were associated with IF gang shot at him, his child, and his baby. And they're trying to get him to identify who one of those individuals were. So it does have something to do with this case. It has something to do with the overall retaliatory shootings that occurred as a result of Mr. Thomas being murdered. And again, in this section, he talks specific about having to come to court. Like, that was his concern here. Like, I have to come to court and I'm going to have to testify about this. He was concerned about doing that. And Your Honor, we believe that that is also why he's changing his testimony in court today. Court during this trial.
Any further argument, Mr.
Well, his life stay in danger.
Mr. Matthews?
No, Your Honor.
Ms. D. Williams? Mr. Harvey? Mr. Steele?
Nothing.
Okay, all right. All right, in considering both sides' arguments in regards to defense 401 being relevance, 403 being unduly prejudicial, or and the state's assertion that is impeachment by contradiction, the court does find it is relevant for the that even using 403 as a balancing test, it is more probative than prejudicial and shows impeachment by contradiction. So I'm going to allow it over defense objection, and I'll give you a continuing objection in regards to that.
Bro, what's the purpose of this?
All defense counsel. All right, let's cover number 9. Number 9 is...
And they got like 900 more to go.
626.30 through 627.05. And as you framed it, Gaither gives speech about the need to put an end to the shootings. All right, sir, go ahead.
I was going to...
You want to play it?
Yeah, can we just play it and then...
Yes. And Your Honor, it's page 181, lines 8 through 12. I'm going to start a little earlier at 626.22.
I can't deal with this shit, man. And I understand that, but you gotta help you right now. We trying to get a stop to all this back and forth shooting. You trying to back and forth shooting? Gee, they only shoot. Well, shooting at you. Shit. We trying to get a stop to this. And we pulling every resource in the city that we can, but we can't be everywhere. So if I gotta pick these motherfuckers off one by one, waiting on evidence to come back, then I'm gonna do what I gotta do. But you gotta fucking, I'm doing what I gotta do, man. Help me out.
We out here, she said.
I'm doing it. Damn, man. Why did I go through this, man? I don't know, but I'm ready to do it. Bruh, I'm ready to get started on the aftermath. I'm ready to get started on that. I can't work towards homicide. I'm picking up the pieces of the aftermath for the homicide. Here.
Your Honor, we stopped at 627.30.
So, Your Honor,
All right, sir.
My objection, again, these statements are allegedly prior statements. I mean, the reason we're playing for the jury over our objection, the defense objection, is because they're prior statements by Mr. Copeland. We have the non-declarant, Investigator Gaither, just talking about the need to end the shootings and how she's going to end the shootings, and the city's putting every resource into ending the shootings. And it really, we're all citizens here. We're all city of Atlanta. We're all Atlantans. It's not the city versus these gentlemen. It's not supposed to be the police force in the city versus these gentlemen. And it's supposed to be a neutral. And that's the impression that the jury is given when they're exposed to, again, this speech. I call it a speech, but whatever you want to call it, by Investigator Gaither, where she presents this as, look, it's, the city and all the authorities and the police department, we're all working to try to put an end to these shootings, and it's you guys and Mr. Copeland, it's your information that will put an end to it, and it's your group that's involved in all this. I believe it's inappropriate. I believe that it invites the jurors to consider it invites them to take into consideration factors that should not be considered in that jury room. And it's essentially an improper argument. If it was made during closing, we'd argue that it's an improper argument. It's an improper. It's, you know, just because it's not a closing argument doesn't make it not improper. It's improper for the jurors to hear that type of talk by Investigator Gaither, especially considering the whole reason that this tape is being played over our objection is not for Investigator Gaither's words, but for Mr. Copeland.
Copeland's right.
Right.
I can understand that. But
Again, you have to look at this in totality, Your Honor. This starts off with Mr. Copeland saying, "Why do I have to go through this, man?" And Gaither is then going into, "I need you to do this. I need you to identify who it is so that I can get started on my investigation, so I can continue my investigation. I can continue my work." So while Mr. Sharp calls it a speech, she's responding to Mr. Copeland saying, "Why do I have to go through this?" And if you look at his body language, he was struggling to move forward and just make the identification. And so she's trying to encourage him to go ahead and make the identification so that she can move forward with her investigation, Your Honor. So again, as the state said earlier, that's in contradiction to what he said here in court. What he said in court, they were forcing him. No, they were talking to him about it. He's responding back to her. I believe in court he may have said they made him say Tay. That's not true. That's what this shows as well. And so given his in-court testimony, this is contradicting what he said here in court.
All right. Any further argument, Mr. Weinstein? No, all right, Mr. Matthews. Nothing, Cat. Ms. D. Williams. Mr. Harvey.
I think Ms. D. Williams is to stand up and say something.
Your Honor, I don't see why this adds anything. I join everyone else, Mr. Sharp's argument. The detectives said we're going to pick them off one by one. Every officer is going to be working. The state is saying that Detective Gaither is encouraging Mr. Copeland. That's not needed. That's not the purpose. We don't just play recordings of me speaking with a witness to say I was encouraging the witness. This is just an out-of-court statement offered to bolster the detective, and that's really not appropriate in my opinion, and it's irrelevant under 4012, and then 3 would be a waste of time. A lot of this, the state wants to play, these are, I believe, 18 hours of recordings. I mean, at some point, they don't get to just play all these recordings, so I would object.
He said, "Y'all not going to play all this and bore me to sleep."
And I can respond to Mr. Steele specifically.
I agree.
If the court may.
Yeah, I'm in trying to kind of see why Detective Gaither, before it starts, we're trying to stop this. We're pulling every resource in the city. We can't be everywhere. So if I gotta pick these motherfuckers off one by one, waiting on evidence to come back, then I'm gonna do what I gotta do. But you gotta I'm doing what I gotta do. I'm doing it. I'd be inclined to take that out, but the other stuff would be admissible under impeachment by contradiction or relevant.
So which line, Your Honor?
Line 8 on page 181, line 8 through line 12.
Okay. That's fine, Your Honor.
It does. I agree with Mr. Steele. It doesn't really add anything to it, and it's for the reasons he mentioned. Okay.
Okay. So line 8 to 12.
Yes. Anybody else have any other comment or any other argument in regards to number 9, 62630 or thereabouts is 62730? All right. I'm gonna, other than that particular omission, or exclusion from, that'd be page 181, using the state's transcript, lines 8 through 12. The rest is, can be played.
Thank you.
Okay?
Yes.
All right. And I'll, again, admit an over objection and give a continuing objection. Does the defendant still maintain that none of this is proper and they should not be played? So, okay. All right. Number 10. And number 10 is 6:30 through 6:31:50. And you are saying that that's 404
Something's going backwards.
A, evidence about Mr. Stillwell.
Shout out to Kiana. Just got me YouTube Premium. No more ads. No more ads. Let's spam the word. Let's spam Q in the chat. No more ads.
All right, sir. Oh,
I'm sorry, Ms. Hill.
you want me to? You want to play it first?
Yes, please.
Okay. All right. Let's play it. What transcript page is now?
Page 185, line
What a waste of time.
Page 186, line 19. And we'll start 6:30.
6:30 what?
I guess she wasn't looking at it serious like how it is. I really wasn't. I really thought they wasn't. I didn't think they would do it. I didn't think they knew to try to shoot me. I'm pretty I thought really would try to do a kill. They showed me wrong. Well, I know him for shit. He been on Twitter going back and forth with Shannon. Yeah. What the hell? I'm telling Shannon, why the hell you ugly? You ain't on Twitter. What's Shannon been up to? Because I know he ain't just gonna sit and let it ride like you getting shot at and all that. I know that. And you know what I told Shannon? Man, that boy deal with him. No man, he'll pay him. You know what Shannon told me that night? The night they shot me in bed. You know, they like, I was crying. And you know, they like, man, bro, hell nah, bro. We take anything you can. I'm like, bro, fuck this shit, bro. Let them have it, bro. Let them have it, bro. They kill me, bro. You know what's going on, bro. Just started with Lieutenant Shannon. Police involved with it. They started with it, bro. We ain't going to jail, so we ain't do, bro. I'm not going to tell you one of these folks think we did this shit, bro. And that's what I told him. He like, she looked at it. She like, bro, I'm telling you, bro. They kill you or they hurt you or the baby, bro. They got to kill him, too. Just like him, bro. They don't get your shell out of it, bro. We already in the battle pay. We with people we never thought we'd be with, bro. Fuck that shit, bro. Let them have it. That's why I really ain't getting in there. If I didn't, like, I feel like.
And stop at 6:31. So sorry, stop at 6:31:51.
All right, Mr. Sharp.
So this testimony or this out-of-court statement by Mr. Copeland about my client has absolutely no relation to any charged conduct in this case. It's propensity evidence. There's no evidence of something that happened that I know of. There's no evidence of something that happened after this date that was supposedly done on behalf of Mr. Copeland in as payback for either the January 28th shooting of Mr. Copeland in the car, or shooting at Mr. Copeland in the car, or the February, I guess it would be 19th shooting of Mr. Copeland, or shooting at Mr. Copeland outside of his house, other than, of course, Mr. Copeland shooting back at those individuals and hitting them in their car. My point being, Mr. Copeland is essentially saying that Shannon has encouraged him to, and said, we need to get payback for them shooting at you. And Mr. Copeland saying, no, I said, let it be, let it be, let it be. This is not testimony about any act that's charged. This is mere propensity evidence that Mr. Stillwell is someone that when something's done to him or one of his friends, he's going to seek retribution from the other side. And again, if the state had overact, and I'm making this up, that happened on March 3rd of 2015, where they allegedly saw the car that was shooting at them on January 28th, then I would say, okay, maybe that has some relevance to this specific act. But there's no act that's charged. And what the state wants, essentially the logical conclusion based on hearing that is Mr. Stillwell is, a hothead that seeks revenge. That's propensity evidence. That's exactly what's not supposed to come in under 404B. And so I would object. It's improper character evidence. It's improper propensity evidence.
All right, sir. Okay. I'm going to use Mr. Adams' favorite saying, easiest decision I'll make today. All right. Anybody else have any other comment about subpart 10, 630, 30 through 631, 50? It's going to be omitted. Anyone? All right. Okay, we've gotten through the flaggings of Mr. Sharp. Does anybody else have any other time periods they wish?
Which one are you talking about, James?
Wish to discuss with the court.
The woman is named Hilton.
All right, thank you, Mr. Steele.
And his young blood
Mr.
right
Harvey?
here is Brown.
Misty Williams. Mr. Matthews.
No, Your Honor.
Mr. Weinstein.
No, Your Honor.
Okay.
And the white guy in the blue suit is named Sharp.
No, it's with reference to my continued objection for severance and instructions with regard to all of this evidence. I don't want that to be deemed to be a waiver on the record.
Okay, Ms.
Thank you so
Harvey,
much,
in no way, I'll note it again for you that you have moved for severance and for 105 instruction, which the court is going to give you continuing objection on, but I'm going to deny that at this time again, okay? All right, sir. Okay.
Oh, Shard. Thank you, Sharp. Sharp.
All right, councils, let's talk a little bit about way ahead in scheduling. I believe that you all have, as well as it pertains to Mr. Copeland, June the 10th interview, which is the longest one. It's 9 hours. Is that correct? All right. Have you all been working on, or I'm going to ask the state first and then defense counsels in terms of what you've identified as to what you're going to play and what you wish to omit?
Your Honor, we sent to defense counsel, I believe on Monday, the areas in which the state, I'm sorry, let me stand up. The areas in which the state intends to redact. Yesterday evening, Mr. Shard, I think, sent me a portion of the areas that they would like redacted. We haven't had the opportunity to look at those. And then I believe Mr. Adams is supposed to send me the secondary portion of that. And so we'll be looking through that over the course of today and this weekend to determine what, if any, areas we can agree to.
We can't agree.
Once we finish talking about June, Your Honor, I will briefly just want to get some clarity on February 21st, but after we finish the June discussion.
What do you mean you want clarity on the
So we submitted
21st?
We submitted some redactions for February 21st. And I don't know if, kind of along the same lines of the conversation yesterday, if there are areas that the defendants wanted in that the state intended to redact. And if there are those same line of area, we understand the court's ruling from yesterday, but we just wanted clarity because we don't know. And it could be an offline conversation I can have with Mr. Shard.
No ex parte meetings.
I think
what their position is.
I think I can answer this. After speaking with other attorneys involved in the defense of other individuals, I believe that there is an objection to the redactions of the timestamps identified by the state. We understand that the state, in their presentation of the case, they may choose not to present some of these excerpts when they play the tape.
Which tape we're referring to?
February 21st, 2015.
All right.
But I believe that the defense is going to seek to admit portions that the state is not going to seek to admit.
And certainly that, I mean, we can have a similar discussion that we had yesterday, or I can authorize, unless there's been a specific objection, I'm going to say you can play it during cross-examination. Like similar to what I did yesterday.
Yes.
And that's fine, Your Honor. We'll
Okay,
object at the appropriate time.
Yeah, if appropriate, yeah, I'll rule upon it. But I'm most of the things that, unless there's clear argument to the contrary, will be fair game on cross. Okay.
Thank you, Your Honor.
Okay, so let's talk about the June 10th interview. So, is it possible for you all to, like, consistent with this has been very helpful for you all to identify the time periods and for us to work down through them and have discussion one way or another? Are you all in a position to potentially put something together by Monday, and so we can kind of go through the June 10th interview?
The good news is we're all operating off the same transcript for June 10th, and there is a transcript. I believe the transcript's about 550 pages. What? I made it through 380, and I've identified the specific spots that I object to, and I believe that other attorneys involved in this case adopt my arguments for those first 380. Mr. Adams is diligently working. He's identified the rest, and he is going to send that information over to the state at some point. I don't want to speak for him, but I know he's been working on it. So I think that the state has given us their proposed redactions, correct?
Correct, Your Honor, but I think we're going to be in the same position. So we really need their redactions, because I think the state is, we're going to redact what we're going to redact, and if they choose to want to play certain portions, we can object at the appropriate time. So I think we really need to know what their redactions are in order for us to have a meaningful hearing, hopefully on Monday.
So right now they have about 2/3, just by the transcript length, about 2/3 of the redactions, and then Mr. Adams is going to get them the rest.
Mr. Adams, will you be finished by Monday?
Oh, absolutely. They'll have them by, I can give it to them by Saturday.
Okay. All right. Okay.
That works.
Wow.
All right.
That's a lot.
So we'll work on, now, as it pertains to, since we'll probably take the most of the day with that, I'm inclined not to call in our juries for Monday.
Thank you so much, Mitch.
Wow. And Your Honor, I'm going to remind the court that we also have the jail phone calls.
Yes, and there's 11 of those at 2.5 hours.
Oh my gosh. I wonder what's an easier way to handle this, though. Wow. I don't know what judge is doing.
All right, and then, counsel, as you all recall, Tuesday the 25th, we'll probably just work from about 9:30 to about probably shortly thereafter lunch. So my inclination as well, I don't think we're going to probably finish with our, it's possible that even if we, that we'll spend or exhaust most of Monday the 24th and Tuesday the 25th getting through the 10th and/or 10th of June, as well as the jail calls, and we may not even be finished with those. So
this is all.
I'm inclined to just tell our jurors have a nice week. Wow. Unless somebody has something to the contrary.
No juries next week.
Anybody? Okay. I mean, I just don't think we'll be.
I object to this being so long.
For them to hear anything at that point. All right. Which leads me to July 1, 2, and 3. More than likely, we'll probably use, if we don't finish up our business with the jail calls, we will probably take that up on Monday the 1st of July. Tuesday, we will probably do the in-camera review of Mr. Copeland's ex parte matter. And I will give you all more pinpoint instructions on that particular time and date. But it more than likely will be the 2nd or the 3rd of July. So that's our kind of work schedule at this point in time to clear those issues before we call back our jurors.
So at this time, we're thinking no jury for the week of the going to the 4th.
Probably not, is what I'm thinking. And I may tell them that so they can adjust they can govern themselves accordingly. But we have a fair amount of stuff to take care of. So,
wow.
All right. Anything else, councils at this point in time?
He wants to get out of here.
If not, I'll see you all on Monday the 24th, 8:30 for an anticipated 9 o'clock still, and we'll queue up the 10th, the June 10th, 2015 interview, and see where that leads us. Okay. All right, anybody else? Okay, all right. We're in recess until Monday the 24th at 8:30.
Who called 11:30? Did anybody call 11:30? Wow. So they started at 9 and basically went 2 hours, 2.5 hours. Well, 2 hours because there was a break. Yo, that is, oh my goodness. Oh my goodness. How do I get this to stop? I don't know, man. Yo, that is craziness. Man. He's really, I don't know. He mentioned that, but it's already gone to the Supreme Court now. So this is all just, I think the defense team is just like, look, we're just going through the motions, in my opinion. I just think they just like, look, we're going through the motions because we want the Supreme Court to call this thing. I don't think you can just say, well, I did wrong, my bad. This is a major, major waste of tax dollars. Hold on one second. I don't have any more ads. Oh my gosh, this is amazing. Okay. Yeah, I have no idea how this is going to pan out because he already has the ex parte meeting. I'm sorry, the Supreme Court is already looking at it, and that's going to take probably 20 days. So that's going to take most of July, let's just say. And then, dude, that's craziness, man. That is so wild, man. That is just wild that is still, man. Yeah. Well, yeah, I don't see how this is going to come out well. I think the defense team is just like, look, we just phoning it in. That's why Steele was like super quiet. Shard didn't have anything to say. I'm waiting to hear back from Infamous Sylvia. She is a YouTuber that literally been going to the courthouse since day one. So she's been there 96 days. Every day she does like a live stream going to the courthouse, walking up to the courthouse, and then she clocks out. And then she like does, I don't know if she tweets or like vlogs on what's going on in the courtroom, and then she live streams back. So I'm going to actually check her page real quick and see if she's talking about it. But that being the case, I think I asked her if she would like to come on and talk about what she's experiencing. So hopefully she will be able to and want to jump on maybe tonight or something like that. I think it'll be a lot of fun to have her. She seemed like not the infamous Sly, the infamous Sylvia. I don't know who the infamous Sly is. That's somebody else. I think the show cause can be canceled because of the mandamus. I think. I don't know that emphatically. I'm trying to check to see if Sylvia's on. Hold on one second. Oh, she's doing something live. Hold on. Is this right now? Oh, this is from earlier. No, she said she's on. Okay, no, the infamous Sylvia is not on right now. Sorry about that. It just said that she was, but that's not true. Unless I missed something. I'll leave it up just in case it pops up because it says it's on, but there's nothing there. Yeah, I don't see it on there, but make sure I'm on the right page. Yeah. Okay, so answer your questions. Let's go check those out. Hopefully we'll have her on tonight or tomorrow to be able to talk about it and see what are her thoughts on it for sure and what she's experiencing sitting in the courtroom. You know what? From my understanding, throwing lawyers in jail is rather common. It's a little bit more common than we imagine. We don't think that they would do that, but apparently they do. And that's why like Gackle has like a strike force because of those kind of things. And that's why they rolled up on Glanville that day and said, we outside. Because they do that. I didn't realize it was such a thing, but apparently it is a real thing. Craziness, right? All right, let's see real quick. All right, let's see if... Yeah, Sylvia is not on, but it says that her live stream is. Well, anyway, we will definitely jump back in when we find her. Hopefully we'll have her come on tonight and talk about her experiences. I'd love to hear what she's thinking about the case and such like that. So just doing another double check. Because it's cool that she actually literally live streams like from the court steps. So I mean, that's kind of wild. I told her, I said, I should come meet you and I could go down there with you one day. Hopefully that would be kind of fun if I could. Sadly, this is going to probably be going on for a while. So I'm still surprised how few people are in the courtroom, but they probably realize like this is just a perfunctory dumpster fire. So I don't know if she's going to do that, but all right, let's see your questions. What did you ask? Yeah, she started live earlier. I actually caught it this morning. I had to go run some errands. I did listen to it, but I don't know if I saw her all the way up to the courthouse and she stopped, but I wasn't certain if she was going to start up again now that court was over, but maybe she's waiting to leave or something, and maybe she will do it, okay? All right, let's see. Let me know if you see her, James. If something's happening, I would gladly bring her on or drop her the link, all that kind of good jazz. So let me see what else. Anybody else? Good folk, good folk. Yeah, I'm glad I ran across her. So I subscribed to her channel. So hopefully we can, again, connect. I mean, she's right here in Atlanta. There's no excuse not to. Yeah, 17 hours of Woody video interrogation, 2.5 hours of Little Woody jail calls. Yeah, I think it's fair to say no jury for 2 weeks. I think that's probably the minimum. Yeah, Apex says, yeah, I was surprised to hear an attorney say that if you have not been held in contempt and remanded to custody at least once, you're probably not a good defense attorney. Yeah. So apparently it's like a real thing. So what happened to Brian Steele was not unique. There we go. It was not unique at all. Let's see what we got. Good family reunion stuff going on. The judge seems super deflated. Hopefully because he's going to get his hand slapped and have to recuse himself. That would be great. Just because this case is getting so out of control. It's making us look crazy. She lives in Rockdale County. Oh, wow. Yeah, so she was driving a long way, so I can believe it. I totally believe it. So hopefully we'll get a chance to have her come on. Woody for Fulton County City Council. I think he'll do a great job. There he is. I am Joe. What's happening? What's happening? Well, thank you so much, Q, for hanging in. Thank you so much. I appreciate you. But yeah, everybody, this has been, wow. They really burned up a lot of time doing nothing. What's going on, Angel Wings? Good to see you. They burned up a lot of time doing absolutely nothing. That was so pitiful. But I noticed that Glanville didn't even mention the immediate appeal request at all. ER petition, emergency petition turns around per Weinstein. I don't know. Response should be filed as promptly as possible, but court may act without waiting on a response. Really? Interesting. Okay. No, I appreciate you, brother. Thank you. I appreciate you, Weinstein. Thanks so much. Lots to consider there. Hopefully we'll get a chance to hear it and see what's going on there. Let's see real quick. Yeah, Sylvia is offline. So she turned off her show. Now it's off. So, well, you know what we can do? Something we can do. What we didn't do yesterday. Yesterday we did the 10, we did the best moments of Woody. So today I got the 10 craziest things that have happened in the YSL case up to this point. So let's bring that in and we'll end it with this. If not, something
else. Mistrial! Free fuck! Mistrial! Aren't you interested in removing the cloud that's hanging over the case right now, Your Honor? If you bring
Sir, I'd be real careful about what you're pleading at this point in time, what you're
Free fuck! Mistrial! Free fuck! Mistrial! Aren't you interested in removing the cloud that's hanging over the case right now, Your Honor? If you bring
Sir, I'd be real careful about what you're pleading at this point in time, what you're stating to the court.
I'm so high right now, y'all. I'm about to go to sleep on y'all now. There has been no shortage of incredibly outrageous moments in the criminal trial of rapper Young Thug, so let's do a full breakdown of some of the most wild incidents over the last 18 months. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. It has been quite a ride so far in the Young Thug trial out of Atlanta, Georgia, hasn't it? When you think about the last 18 months or so, we have seen some absolutely wild, unforgettable moments that I'll tell you right now, I don't recall seeing in other trials. I really haven't. And that's...
It looks like people are saying that the screen froze. Let's see what's up. Make sure. Okay, so are you saying it? Okay, what? Because I paused it right here. All right, so it looks like. All right.
Okay. Michelle, aren't you interested in removing the cloud that's hanging over the case right now, Your Honor? If you
Sir, I'd be real careful about what you're pleading at this point in time, what you're stating to the court.
I'm so high right now, y'all. I'm about to go to sleep on y'all now.
There has been no shortage of incredibly outrageous moments in the criminal trial of rapper Young Thug, so let's do a full breakdown of some of the most wild incidents over the last 18 months. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. It has been quite a ride so far in the Young Thug trial out of Atlanta, Georgia, hasn't it? When you think about the last 18 months or so, we have seen some absolutely wild, unforgettable moments that I'll tell you right now, I don't recall seeing in other trials. I really haven't. And that's not me saying it lightly. I cover trials all the time. Now, this, of course, is the case of rapper Young Thug, whose real name is Jeffrey Lamar Williams. He and his co-defendants, they were indicted on a laundry list of charges, including the main underlying charge, conspiracy to violate the state's RICO or racketeering law, namely that they agreed to illegally obtain property and money through a pattern of criminal activity in furtherance of a criminal enterprise or gang known as YSL, or Young Slime Life, as alleged by prosecutors. And when we talk about conspiracy, there has to be an agreement to break the law, and there has to be overt acts or steps that are taken in furtherance of that agreement. Now, overt acts, they don't necessarily have to be crimes. They just have to be certain actions that were taken. And the idea here is that Williams and others had an agreement to participate in gang activities, and there were 191 overt acts taken in furtherance of this YSL gang. So no wonder this trial is taking quite some time in order for the prosecution to prove all that. Now, more than 24 other men were charged as well in connection with this case, but that number has dwindled down by the time we got to the start of trial. That was for various reasons. Their cases were severed. They took plea deals. Now, the defense is suggesting that YSL is merely a record label and that there is no gang or criminal enterprise or association here. So we have dedicated a lot of sidebars to what has been happening in this case, but now we're going to aggregate it all together. This is going to be a full compilation of some of the most wild moments in this trial, and we're going to start from the beginning with what happened in jury selection. Now, let me preface this by saying that as we do this recap, the judge presiding over this case, Judge Earl Glanville, runs a no-nonsense courtroom. You break his rules, you step out of line, he will punish you for it, okay? To give you an example, 2 jurors learned that the hard way. So one prospective juror improperly recorded the jury selection process proceedings on her phone, and Judge Glanville had her arrested.
Why shouldn't I hold you in willful contempt?
Okay, so I'm going to explain everything that happened that day on the 17th of March.
Okay, but before then, do you recall this court giving you the ad nauseum admonitions about acceptable behavior?
About having phones out?
Yes.
At the moment when we came in.
Didn't I tell you to turn your phone off?
It was, I'm going to be truthfully and very honest. When it was a lot going on, we had just come from different
Answer
floors.
my question first, and then you can explain it. Do you recall us telling you to turn off your cell phones?
Yes, sir.
Okay, you also recall me going through a litany of different things that would cause us to potentially put the case in jeopardy. Do you remember me saying that to you?
I mean, I couldn't hear. It was so much people. It was so many people talking and so many people doing different things. So people were talking when I was giving that admonition to you?
Yes. Meaning that you didn't hear it? You didn't hear any of the 10 minutes that I went through on the record about the things you couldn't do? Specifically, you couldn't research on Google. You couldn't go ahead and otherwise contact your friends on social media. Do you remember that?
Well, I remember the part when you saying we had to, but I didn't hear the turn off the phone.
Remember
until the middle
me
of the
talking
speech.
about no social media?
Yes.
Do you remember me also pointing to the placards that are on the wall about social media and the things you cannot do?
And I didn't see that until after the fact.
You don't recall me pointing that out to you?
No, sir.
I tell it multiple times for multiple reasons, and you just decide you're going to just do what you wanted to do.
It's not
Pull out your phone
doing what I wanted to do. I just
Well, you pulled out your phone and videotaped our proceedings, and that was in direct violation of this court's order. So I'm going to sentence you to 3 days of in jail, and that will otherwise satisfy your contempt.
But there was so much going on. I suffered.
That doesn't excuse your behavior, and it doesn't give you.
I didn't hear every.
Madam, that does not excuse your behavior, and it doesn't provide it's an excuse for behavior.
It's a big deal. It's a big deal recording the jury selection process because it endangers the defendant's right to a fair and impartial jury. And Judge Glanville explained that a punishment, like a sentence here of 3 days in jail, we do that for a variety of reasons: to deter her and others from doing this, rehabilitation, re-entry into society, retribution. Now, while Judge Glanville sentenced her to 3 days in jail, she was actually released 5 hours later, and I would wager to say that she probably learned her lesson throughout all that. Then we had another prospective juror who apparently didn't return for jury duty during the jury selection process. No, instead, she apparently went on a trip to the Dominican Republic. Now, that might sound bad on its face, but let's provide a little bit of context here. We'll hear how it played out, because she explains that she didn't see the jury duty notice until late, and then she had this trip. And you will hear Judge Glanville's decision, which was something.
Actually, just receiving the jury summons. I travel a lot. I've always traveled a lot globally for work and other things. But I traveled. I wasn't here Thanksgiving week, the week of the 28th. So, and I don't think I returned until like the 16th. I was in the UK. And because I live with my grandmother, I didn't go because I was exposed to travel. Didn't want to make her sick. So I don't think I actually saw the summons until like the 30th.
The 30th of December?
Yes. And I also knew I had these medical appointments. I have 5 weeks of scheduled infusions for the next 5 weeks, starting the 20th upon my return. But they said send the email, and I did the first thing the next morning. I also called aggressively trying to get through. And that voicemail, I called it, still, I checked yesterday, it still says if you have an issue, send it with your jury summons, send an email, and you will not be penalized or something. So I sent that. I didn't really know I was in violation until the sheriff showed up.
You know, there are a lot of people that were inconvenienced. I mean, severely inconvenienced. You're not the only person that outlaid money. I examined people yesterday who lost literally hundreds of thousands of dollars trying to be here, and I have to make decisions in regards to that. But I didn't even get a chance to examine you about your circumstance because you went to, you said, okay, I'm going to go. What I then want to do is, in order for you to satisfy your contempt, I'm going to commute the 20 days and require you to write a 30-page paper on the importance of jury service. Here's the criteria. You'll have to do APA style. You're going to have to use at least 10 primary sources, 10 secondary sources.
30-page paper. I told you, I've never seen anything like that. That is a punishment. Yeah. Now, Judge Glanville said she shouldn't have just left. She should have figured out a way to bring this to the court's attention so that they could work it out. Now, I imagine she and anyone else who might be serving on a jury in Judge Glanville's courtroom or other courtrooms might be thinking twice. But I should tell you, it wasn't just jurors getting in trouble. No. How about when someone allegedly smuggled marijuana to one of Young Thug's co-defendants in a pair of shoes? Or when another co-defendant's mother was arrested for trying to sneak tobacco products and rolling papers in a bag of clothes? Or when another contraband incident ended up halting the jury selection process for an entire day? Here's what Judge Glanville had to say about it at one point.
We've had yet another instance of alleged contraband being introduced to our space. And as a result of that and a subsequent investigation, one of our inmates unfortunately had to go to Grady Hospital. The other thing I would just invite counsel to talk with their clients about, I know I've mentioned this 3 times now, what is considered to be acceptable behavior. This is the 3rd time that we've had contraband introduced into this in this space. The court's concern is that this may pose issues to them remaining and being present in this space.
And in one of the more memorable moments, one of Williams' co-defendants, Khalif Adams, was allegedly seen on camera walking up to Young Thug and handing him something. Now, prosecutors say that it was a Percocet, which is a brand of oxycodone. And to his credit, Young Thug immediately handed the pill to law enforcement. Adams was taken to a holding area where his attorney alleges that Fulton County deputies searched him, but also tased and assaulted him. Adams ended up going to the hospital. Adams was already, by the way, serving a life sentence for murder, charged with conspiracy and attempted murder in this case. But given what happened in court, he was also hit with drug possession and obstruction charges. But it wasn't just jurors held in contempt of court or defendants getting in trouble with the court or family members or friends of defendants. No, it was also attorneys. Yes. So defense attorney Anastasios Menendez represented defendant Miles Farley. And one day it was reported that Menendez was undergoing a routine check of his bag when he was coming into court, and officers found a bottle of prescription medication and arrested him. As officers closed in on Menendez, he allegedly went to toss his phone to another attorney, but apparently it hit one of the deputies. So he was charged with simple battery on a law enforcement officer and possession of pills not in their original container and disrupting courtroom proceedings. Menendez got his own attorney who said that the battery charge was dropped. Menendez was released from the Fulton County Jail on $5,000 bond. But that wasn't the only time Mr. Menendez had been in trouble with the court. He had been held in contempt another time. Now, the reason not entirely clear, but what we do know is that he was ordered to pay a fine of $250 and buy all of his colleagues lunch. Very unique punishments put forward by Judge Glanville. So at one point, the judge wanted to know if Mr. Menendez had actually bought lunch.
You were held in contempt, young man. And if you want to revisit that again, we can certainly open it up. But I satisfied your contempt by you paying $250, which you did, and I have a receipt from that of your choosing, which that was done to Miles College. I have that receipt here. And the other thing was to purchase lunch for each of your attorney colleagues in this case on Friday, March the 17th from Jason's Deli. So prong one's been settled. Prong two was you're supposed to buy your colleagues lunch by that date. Mr. Menendez, this was in satisfaction of me not sentencing you to jail for 20 days. So if that's the case, well, then I will revisit the basis for your contempt. But I thought that, and in fact, I'll have Ms. Weaver go ahead and pull that order, pull the part of the record. But I did, in fact, I did not hold you in, I did not go ahead and sentence you to the 20 days. I said that this would satisfy, once you apologized, I said you can pay, because remember, you were going to do I was going to have you do a report as well, or a written product. I was also going to, but instead of doing that, we settled on the $250, and we settled on your buying lunch for your colleagues on the 17th of March. So that was my understanding.
My understanding was that I apologized and that I was doing that to sort of show how serious the apology. I'll still buy the lunch.
And that will satisfy. Then that will satisfy this court's concern. Okay.
And it doesn't end there. No, of course, there was recently when Young Thug's lawyer, Brian Steele, got in trouble. He was held in contempt of court. And this was a very, very controversial move and drew the ire from many in the legal community. So Brian Steele had become aware that an apparent private meeting took place between Judge Glanville, prosecutors, and a key witness named Kenneth Copeland. It's called an ex parte meeting. It's in the judge's chambers. Defense counsel was not alerted of this meeting. They were clearly not present for this meeting. And Steele took issue with this because he claimed that his client should have been privy to this, especially since Copeland, who was going to potentially testify about Williams' involvement in the murder of Donovan Thomas, was allegedly threatened by prosecutors and the judge in order to testify, and claimed that he would testify that he was responsible for Thomas's murder, that he wouldn't tell the truth while on the stand. So very important information that allegedly happened behind closed doors. Well, Judge Glanville didn't seem to focus so much on the content of the meeting as much as he was upset about how Brian Steele found out about it. So Brian Steele complains about this meeting, and then let's hear what happens.
And then somehow that email was CC'd
to me that never. Mr. Steele, can I interrupt you for just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that? Well, I'm disturbed too. What I was told was that Mr. Copeland said. And you haven't answered my question yet. I'm not going to answer that question. You're not? No, I will not answer that question. Why will you not answer that question? Because I want to make sure that what I say is accurate, and I'm not trying to get anybody else. I'm asking you, how did you get this information? I'm not telling the court. What I'm saying is based upon information. Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems. We can have this. I have problems right now. I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court. It concerns me that you have proprietary information. Why is it proprietary? Or information that you should not be having that was ex parte. Why? With a party. Why? State of Georgia. How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said actually all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did. Mr. Steele, I still want to know, how did you come upon this information? Who told you? What I want to know is why wasn't I there? Why did Sir, I'm going to hold you in contempt if you don't tell me who that. Tell me who this information is. I don't want to be held in contempt. Well, I'm not answering that question. That's attorney-client privilege information.
So the judge called for a 5-minute recess, and when he came back, he still demanded to know how Brian Steele had learned about this private meeting in his chambers and what was said. And this is where it gets complicated, because it seems Steele is saying, you're giving me an impossible choice here, Judge. If I tell you, I violate the ethics rules. And if I don't tell you, I'm going to be held in contempt of court?
You need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt. I understand. I don't want to be held in contempt. And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious. Yeah. That's why I raised it. It is that serious that we should have been there and it shouldn't have happened. Sir, that's a whole separate issue. And that's why ex parte conversations are recorded. Why would it be ex parte? You're acting like it's ex parte under seal. It's ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation. I've never asked this honorable court or any court to meet with me and a witness. Sir, you're straying off the issue. I'm not. The issue is, how did you get this information? I understand the issue. I promise you, I understand it. But what I'm trying to ask you is, if you look at Comment 5, this is how I understand the law. You can't violate something and then use privilege. Okay? I'm not violating anything. Okay, but that's why I'm saying, how did you get the information? But just listen to what I'm trying to tell you. You're threatening me with contempt. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't. Let me tell you, I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, or you're asking me, I'm not saying you're ordering, but to give you information, and you're saying it's not sum and substance, but I'm telling you, I can't do that under the bar rules. All right, well, I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it. I can't do that. Yes, you can, because I have an idea how you got it. Well, your idea. I have an idea how you got it, but that's improper, sir. Your idea may be wrong, and you're asking me to listen. I told you the first time, and I'm not going to breach that confidence. I don't want to hold you in contempt, but this is that serious. Judge, you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Okay, Steele said he couldn't reveal his source of the information. Glanville said he could, ended up holding Brian Steele in contempt of court. ordered him to spend 20 days in jail, that's 10 weekends, and actually agreed that he would share a cell with his client, Mr. Williams. But the Georgia Supreme Court stepped in. They paused imposition of the sentence while the appeal of that contempt plays out, so Brian Steele will not be reporting to jail. It is being reported that it seems the judge believes he figured out who relayed that information to Mr. Steele, because the judge seemingly doubled down and ordered a show cause hearing to be held with Mr. Copeland, Copeland's stand-in attorney Kayla Bumpus, as well as prosecutors, everyone that was at that ex parte hearing or that meeting. And again, it seems based on the words and the language that he used that he believes Ms. Bumpus was the one who relayed that information to Mr. Steele. So they all have to show cause why he shouldn't hold one or more of them in contempt for sharing information about the ex parte meeting that's set for June 25th. But the fallout from all this didn't end there. No, another defense attorney, Doug Weinstein, tried to have Glanville removed from the case, and it got tense.
You can't file a motion to recuse for ruling that a trial judge makes, okay? And that's what you're doing in this particular situation. You're saying you don't like what I ruled upon. You're alleging some facts in an affidavit that support that decision. Because if that were the case, then no trial judge would be able to sit through a trial and give adverse rulings.
You're always talking about how the appellate court...
No, because if I grant the certificate, it stops the case, okay?
I don't agree with
And I'm not going to do that.
I don't believe it stops the case.
I'm not going to do that.
And if
You can appeal it at the end of the case. If I'm wrong, I'm wrong. Hey, I'll live by it.
But aren't you interested in removing the cloud that's hanging over the case right now, Your Honor? If you grant...
Sir, I'd be real careful about what you're pleading at this point in time, what you're stating to the court. I just, as a matter of professional responsibility, remember, we haven't nugged out all of the issues involved in that affidavit. And I would be very careful if I were you.
Now, in case you didn't hear that, Weinstein said to Glanville, the judge, that wasn't he interested in recusing himself to remove the cloud over this case? Wow. And look, it's an interesting question because essentially Glanville is a witness in this case. The argument is he should allow a separate hearing to be held on the contempt issue because he's accused of holding this allegedly improper meeting and intimidating Copeland. That's the allegation. That's the argument. Anyway, moving away from that. This was also not the only interesting back and forth between the judge and Brian Steele. No, when an officer took the stand to talk about stopping Young Thug in a car and allegedly finding a stolen gun in the vehicle, Steele holds the weapon in court in a way that Judge Glanville wasn't too happy about.
Through your work, you find out that this item, from running a computer check, comes up stolen from the serial number. Is that how it works? Yes. Okay. And you found the item, though, underneath the passenger seat on the floorboard. Is that right?
I need to teach you about handling weapons. Please point the muzzle always downward, no matter if it's unloaded, okay?
I know it's unloaded, but yes,
You make everybody nervous, okay? To include Mr. Kearns, who you're pointing at.
All right. I apologize, Mr. Kearns.
Now, I don't want you to think that the judge just had it out for the defense. No, the judge also had issues with the prosecution, too, that made for some very wild moments, like this back and forth with prosecutor Adrian Love. So the issue here concerned Mr. Weinstein, again, talking about him. He's representing Diamante Kendrick, and he wanted to suppress a 2015 police interrogation video of Kendrick because he claimed that the investigators violated his client's rights by asking him more questions after he had asked for a lawyer. We know that, 101. You ask for a lawyer, the questioning stops. Well, the judge watched the police interview outside the presence of the jury, and he was wrestling with the issue when there was this interaction between prosecutor Adrian Love and defense counsel, and even the bailiff had to get involved.
The thing is that, Your Honor, we did not...
You're arguing with me now, Ms. Love. So can we stop at this point in time?
Where it specifically says that a lawyer, a suspect who asks for a lawyer at any time during a custodial interrogation may not be subjected to further questioning, as the court has said, by law enforcement until an attorney has been made available or until the suspect reinitiates the conversation.
Your Honor, at some point,
Your Honor, I'm sorry, I'm talking, and I don't know why I am being interrupted. I will not stop.
Hey.
I was speaking.
Ms. Love. Y'all got.
I'm sorry, I was speaking.
Both y'all can't talk at the same time.
I know, I was speaking, and I expect you to allow to speak when I'm speaking.
Hey, both of you all need to just take it down a notch.
And so, Your Honor, if I may finish, because I was the one speaking before Mr. Weinstein interrupted.
But you continually engage in this pattern of behavior, Ms. Love. You don't want to accept my ruling.
Your Honor,
I know you're being an advocate, but at some point, stop.
Look, this is a serious issue, right? When a suspect, a defendant, asked to speak to counsel, the questioning stops. And anything that is gathered after that may not be able to be used in an upcoming trial. Now, during the course of this trial so far, there's been a lot of back and forth between Love and Judge Glanville. And again, makes for these very memorable moments.
Given that we have witnesses on this list like Detective James Thorpe, who is at the Atlanta Police Department every day, and
You told me that yesterday. What did I tell you? What did I tell you yesterday? I'm not going back through this, Miss Love.
I'm not asking that.
Monday the 4th, we'll look at a hard list for the court's consideration. And is there anything else at this point in time?
Your Honor, did juror number 39...
Would you stay out of my business, Miss Love?
Oh, well.
Stay out of my business.
Judge,
Look,
I'm sorry.
I've been doing this a long time. Yes, I have, yes. And if you really must know, she's going to reschedule her appointment to the week of the King holiday. You happy?
It's January.
No, you're not happy. But anyways, that's the explanation you're going to get. I'm on top of it. Okay.
So that was 6 months ago.
Something, to say the least. Now look, when I think back on the past 18 months of this trial, there are so many moments. Like, how about when somebody over Zoom interrupted the proceedings?
Free fuck, mistrial! Free fuck, mistrial!
Or when the judge admonished someone in the courtroom in the middle of testimony.
Excuse me, Miss Love. Madam in the black, get rid of your gum. Remove yourself from my courtroom and get rid of your gum. In the earrings, you, get rid of your gum.
But I'll tell you, some of the most wild, memorable moments have come from witnesses, like Adrian Bean, who prosecutors were hoping would tie Williams to criminal activity. But he didn't seem to really want to be there, and he seemed to admit something quite interesting on the stand.
All this going on right here on this, got me up on this stand, talking about this and that third, all this extra stuff that's going on, Your Honor. Am I on trial, Your Honor?
Sir, you just have to answer the questions, unfortunately, at this point in time, okay? That's all I can tell you.
Am I on trial?
No, sir, you are not on trial. But you have been properly summoned here as a witness, and you're subject to examination until I release you.
I never consent to do none of this, sir. I ain't signed nothing. My name ain't on nothing. They come get me. Y'all don't threaten to lock me up. Hey, I got a family too.
You just heard that you explained that you qualified it as the detectives and police. And I asked you the authorities, the police, the prosecutors, I just made it broad, that they forced Jeffrey Williams into it. Did you hear you say that?
Man, can I get a water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all ass. I ain't gonna tell you no lie.
Yes, you may. We're going to take a break.
Yep. Then let's go back to Kenneth Copeland, a.k.a. Little Woody. He had some interesting moments as well.
And Mr. Copeland, good afternoon. Do you want to be here?
Ma'am,
Do you want to be here?
I'm here.
Okay. Are you going to let me ask you some questions?
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
I plead the fifth.
By the way, what's interesting about doing that is, let alone pleading the fifth to that question, was that the fact that he was granted use immunity in this case, meaning his testimony can't be used against him by state prosecutors, so he can't necessarily invoke that privilege anymore. There is an issue legally if what he says could be used by federal authorities. But look, at the end of the day, he was held in contempt of court for not participating. But remember, the prosecution needs to tie Williams to the 2015 shooting death of Donovan Thomas, a.k.a. Big Nut, an alleged rival gang member. Shannon Stillwell and DeMonte Kendrick, two of Williams' co-defendants, they have been charged in connection with the shooting, and Williams himself is accused of renting the car that was used in that alleged drive-by shooting. Now, the prosecution needed Copeland to confirm that he knew these men allegedly involved in the Thomas hit, but even that was difficult.
Tell me if you recognize individual in Stacy's Exhibit 350 Yankee.
I recognize myself.
Okay. Do you recognize anybody else in 350 Yankee?
Myself.
Do you recognize anyone else in 350 Yankee?
Their face is covered up.
Okay. Do you see someone's face who's not covered up in 350 Yankee?
Yeah.
Okay. Do you recognize who that person is?
I can hardly tell.
Okay. Is that Shannon Jackson? Your Honor, at this point in time, I'm turning to impeachment. Do you know someone by the name of Demikion Garlington?
Street name.
Little D.
For sure.
Little D.
How do you know Little D?
I didn't birth him.
I'm sorry, say that again.
I almost birthed him.
You almost birthed him?
Yeah.
Tell the jury, what do you mean by that?
I mean, he my son.
Okay. And let me ask you this. Do you know another person who's referenced as Little D?
What you mean?
Do you know someone who's called Little D from Cleveland?
Oh, I heard of him.
You heard of him. Okay, we'll talk about him in a moment.
You said what now?
Tell me who you recognize in 380 Yankee.
Oh, me and Coco.
Who's Coco?
The ugly boy right here.
Okay.
Let me give you a little background to this as well. So Copeland, he was seen speaking with police in an interrogation tape that leaked online. He was supposed to be the star witness or a star witness for the prosecution.
He got shackles
because he
on
had
there.
previously told investigators that Williams was connected to criminal activity. But Copeland said he just said what he had to say to get out of trouble. And as he explains this, he even gets, of all people, the court reporter involved.
Did Thug ever speak with you about his relationship with Nut?
No.
Did you ever observe Thug and Nut together?
I never saw those two together. I never been around those two together. No, it never crossed my mind.
So how were you able to tell Detective Gaither that Nut and Thug was cool?
Because they're questioning me and I'm trying to get them off of me. And she asked me questions about Nut and Thug, I guess. And I'm telling her whatever she asked me, let's say she asked me a question about the sky. I'm gonna say, yeah, I seen the sky. It's blue. Whatever she asked me, I'm gonna agree to that. I'm gonna say whatever she asked me. If she asked me about this reporter right here, I'm gonna say, yep, she's sitting outside me with white tennis shoes on. I'm gonna say something. Just because I want her to believe I'm telling her the truth. That I want her to get me out of jail.
What, she has on white tennis shoe, don't she?
Don't you got on white tennis shoes? She got on Chucks.
Right, and they white, right?
What color your shoes is? Okay. She got on Chucks.
So you telling the truth?
What color your shoes is? She said they white.
Right, so you're telling the truth then?
Well, it depends.
Also, I got to call this out. Do you remember when I said that Kenneth Copeland was in that ex parte meeting with the judge and prosecutors being represented by Kayla Bumpus at the time? She was standing in for his regular attorney who had gone out of town. Well, as I said, the allegation has surfaced, and based on Judge Glanville's statements in court, it seems to suggest that Bumpus may have been the one who told Brian Steele, Williams' attorney, about the ex parte meeting and caused this whole mess. Now, she and Copeland, as I said, will have to appear at a show cause hearing in a couple of weeks to determine if they should be held in contempt. But after all of this chaos surrounding the ex parte meeting, Copeland decided he didn't want her to represent him anymore.
Sir, Mr. Copeland, is it your desire to release your counsel at this point in time?
She fired.
She fired.
She's fired? Okay.
And according to Ms. Bumpus, she had already been fired even before Copeland had testified. But there was another witness I want to talk about, and this witness is identified as A.B. She apparently didn't come to court at first, defying a subpoena that she says she never received. This witness was allegedly the victim of an armed robbery in 2013, reportedly involving Williams, which seems to not be part of the indictment. But Prosecutor Love told Judge Glanville that she had spoken with the witness several times about the court needing to hear her testimony and said that the witness indicated she did not want to come to court. So she ended up telling Love that she was in the hospital, couldn't come in, but the DA's office says officers found her at home and actually arrested her on a material witness warrant. But if the prosecution then expected her to be particularly cooperative once she was on the witness stand or to give some bombshell incriminating testimony, they were wrong.
Do you recall telling the police that you turned your back on them to walk into the kitchen to make your baby a bottle?
No.
Do you recall telling the police that when you went to the kitchen, Thug's brother put a silver 9mm to the back of your head?
No. And my baby didn't even drink bottles. My baby was breastfed. So no.
Wow.
Did you tell the police that the two suspects, that Thug, his brother, and DK demanded money from you and your gun?
No.
Now here's where it gets even more interesting, because AB was cross-examined by Keith Adams, another member of Williams' defense team. And one of the areas of focus was that she was allegedly hit on by an investigator in this case.
Mr. Hamilton had contacted you prior to yesterday, is that right?
Yes.
Mr. Hamilton had harassed you, is that correct?
Yes.
In fact, you told us when you were back there that you didn't want to come out and see him because he had sexually harassed you, true?
Yes.
He wanted to meet you, supposedly to talk about the case.
Yes.
But now how about the next one? That same night, Wednesday, February 7th, 6:45 p.m., where he says, hit me up if you're bored later. We're not going to talk shop. Remember that text message?
Yes.
Did you talk to him later on?
Yes.
I actually did a review of this this situation where one of the ADAs, one of the people working in the ADA's office, was flirting with a. We went over this, and I'll try to find the video clip. And we're talking about it's basically like a big dating pool. And to answer your question, Violet, I'm gonna try my best to get down there. So I do want to give you a shout out. Thank you for supporting the RICO Defense Fund. I do plan on going down there one day. It is open to the public, and I'm sure it's probably not that exciting, so there's not a lot of people going. But I'm trying to connect with infamous Sylvia to see if we can go down there one day. All right, we're almost done.
Did y'all talk shop?
Yes.
What do you want to talk about?
Going out.
Going out? Going out as in walking out the door or going out on a date?
Walking out.
A date.
And this is February 7th of 2024, this year, when the investigator for the DA's office is supposed to be talking to you about a case, but in fact is calling you, talking to you about going out on a date. Is that true?
Yes.
Yikes, this case, am I right? Now I'm going to end it here with the testimony of Trontavious Stevens, the apparent co-founder of YSL, former co-defendant in this case who took a plea deal. And as we've seen during the course of this trial, you wonder how credible a lot of these witnesses are, whether or not they're not so forthcoming with information. And one of the most memorable moments was him struggling with the understanding of the word snitch. And at one point, prosecutor Adrian Love brought up the idea of snitching. And Stevens didn't really seem to know what she was talking about.
What does snitching mean to you?
It doesn't mean anything to me, but I'm aware of the term.
How are you aware of the term?
I've heard the term.
How do you understand the term to be used?
Dopeness. Okay.
I'm not aware of the term to be used. Yeah, indicating that a person is a law enforcement or something. Indicating that a person is law enforcement or some nature.
So are you able to use snitching in a sentence?
Yes.
Please use it the way you understand it to be properly used in a sentence.
I heard someone is a snitch.
And please explain how, in that sentence,
What are they doing?
snitch refers to law enforcement.
I can't.
Why did you use it that way?
I mean, I've seen movies, and that's the direction that the movie was going in. Maybe even used the term. Maybe even got it from like movies. Yeah.
And the way you understand the term, is it a good thing or a bad thing to be known as a snitch?
I really don't fully understand the term.
Now, as I was going through all this and compiling this script, there's a lot more. Okay, but we didn't want this episode to be like 9 hours long, which, by the way, very well could have been. But I'll tell you what, we are not even close to this trial being done. And I am sure the moments will keep on coming.
All right, so that was the 10 craziest things that have happened so far in the YSL case. And again, like, that's not the end of it by any means or measure, because I can think of at least 3 things I know that he didn't talk about. Other attorneys getting arrested, somebody's computer being hacked and showing inappropriate stuff on the screen, craziness. But yo, this has been wild. But I want to thank y'all so much. Hey, shout out to Miss Mandy Reacts. She does a great job of addressing, let me get it right here, snitches get stitches. So Miss Mandy does a great job of doing true crime reactions. So definitely check her out. If you could, moderators, could you please drop her link in the chat? But please don't forget to drop by and click on Violet Chikune. I'm gonna go ahead and pull up her video, her link right here. From Berean Babe, she does a great job of giving biblical responses to the culture and such like that from a Christian female perspective. She does an excellent job. So please check out Berean Babes. Violet, please drop your link in the chat as well so people can go by and check out and see what you're up to, what new projects you're working on. They'll definitely be pleased and happy that they did. I want to thank y'all so much for hanging out with me. I know that this is not as grandiose and as exciting as we expected it to be, but you know, it is what it is. But I thank y'all for hanging out with me, because you in the live chat make this show worth it, if you will, because you all, your interaction with one another, going back and forth, chit-chatting with everybody like that, makes this thing, keeps the engagement high, keeps everybody engaged and so forth, and makes it fun. So I'm looking forward to, I'm planning to, hopefully we got things going on at the studio that are out of the way. So we actually have an engineer now that'll be doing a lot of the engineering. So that being the case, I can work from home. So the plan and the intent is to hopefully do most of these, do a live stream about the YSL case on a regular basis. I'll keep you all posted on that. Just kind of work out a couple things, iron out a couple things with kids going to camps and stuff like that. But that is the plan. That is the intent, as well as to get some guests. So hopefully we'll be having some guests come in to give some recaps, so on and so forth like that. So again, I'm looking to connect with Infamous Sylvia. I'm looking to connect with other legal professionals to give us, again, some perspective on what's going on in this case. Why are certain things move like they do? Why does it take so long to do an appeal? Like, if the Supreme Court is already aware of what's going on in Glanville's office court, why does it take so long? That doesn't make any sense. So hopefully we can get some answers to that. But most importantly, hopefully we can just give a good perspective on what's happening with this case. Eventually, the Trump interference case will come back. So we'll be talking about that. There's other cases that are going on. I would love to talk about those, as well as I think there's like a little small election coming up in November. So there's a lot of stuff happening. And as long as y'all ride with me, we'll just keep on talking about it. So I really do appreciate it. Thank you so much for the encouragement. Thank you so much for the very gracious, very kind super chats and super stickers. Thank you so much for the buy me a coffees. It means a lot that you all support me and what we're doing here. All of that goes to help make me a better YouTuber and a better content creator. So don't be surprised when you see my game get stepped up a level or two. So thank you all for that. I really do appreciate it. Thank you so much to the moderators. Can y'all do me a favor? Just spam MODS in the chat, because the moderators, man, and let me just say it again, they are invaluable. I cannot say enough what we would not be able to do if we didn't have moderators. So really want to thank y'all so much for that. Okay, well, Mandy, here's my email. Just tell her to email me. I have no shame in reaching out and talking to people. So here's my email, Mandy. Just tell her to give me a shout. I'd love to talk to her. Absolutely. But again, I just want to say thank you all again to everybody, all of the moderators, because you all make this thing work like a smooth, well-oiled machine. It really does. Because y'all know I would be in trouble if I had to put all these links up and all that kind of stuff like that and check on the chat while I was doing what I'm doing over here. So really want to thank you, moderators. And I thank you all, because you all are the best live chat on the planet. I know a lot of people are trying to claim it, but let me tell you right now, they got to show it. And you all show it every single time you click on that this is the best live chat on the planet. Thank you so much. If you did not hit the like button and you do like this kind of content, just hit that like button. It doesn't hurt. It doesn't cost you anything. And if you didn't like this content, just hit the like button like 3 times. I mean, just hit it 3 times. It kind of does the same thing. But anyway, I really do appreciate y'all for sure. My goal, my plan is to hopefully stop back by tonight. Hopefully have a guest to kind of give us a recap. I'm waiting for it to hear back. If I do, and if I can, I will be putting out a community post, and I will be putting up the thumbnail that will be going live tonight to talk about what's been happening and answer your questions. The goal is to be able to answer your questions. So for you all to come on, or rather ask your questions in the chat, and have our professional or our guest answer your questions. So that's my goal and my intent. So let's get ready to bug out of here. I thank you all so much. I appreciate you. Have a fantastic rest of your Friday. Have a great end of the week. And by God's grace, I'll see you real soon. Take care, everybody. Grace and peace. Take care.